Good morning. I'm Jim Libby, Chairman of the Board of Directors of the Association of Food Industries. Welcome to our town meeting. Our program today is wide-ranging and an engaging one. In this period of the pandemic, AFI has remained a tireless and effective advocate for the food industry that can offer professional-grade insights into current trade issues. Today's presentation will be taking up a wide range of regulatory, trade, and financial questions, happily leavened with a pinch of humor. Thanks for coming, and let's start the show. Thank you.
Well, thank you, Jim. On behalf of the entire membership, I want to thank you and the entire board of directors for the ongoing time that you and the others put in on behalf of the entire membership. So particularly this year, it's been a little different, but the board has come through with flying colors as it always does. So we definitely appreciate that. Just want to welcome everybody. For those who don't know me, Bob Bauer, I'm the president of AFI. And we too have been doing things a little bit differently this year, a little curveball thrown at us. And we appreciate the members working with us and helping us, and the responsiveness to the members. And I can give you a great example. We just last week, we got about a 12-hour, maybe 18-hour kind of notice of a letter to support the miscellaneous tariff bill. And we had 7 items on that bill, and there's thousands of them. Yet the number of signers on the bill, AFI accounted for nearly 10% of the signers onto that letter that was then submitted to members of Congress. So I thank the membership, and I congratulate you. That's the way that our voice can be heard, and it needs to be heard, because imports are always looked at a little bit differently than domestically produced product. So we have to continue to do our best to make sure that our voice is heard and people understand the impact and the benefit that in our case, imported foods bring to the economy. So thank you for those who did that. I'll be sprinkling some things in and out during little breaks or extra time throughout the next 2 days. But that was sort of how I wanted to lead into things. I do want to thank, as I mentioned, there's a little bit different way of having to bring everything together here. And I wanted to just bring attention to 2 staff members in particular from AFI who've had a lot to do with what we're going to experience over the next couple of days. So we have one who's behind the scenes. Ed Spader is the proverbial man behind the curtain there. And we do pay attention to him because he is instrumental in helping us bring all this to you on the technology end of things along those lines. So thank you, Ed. And then Erin Jordan did the yeoman's work in terms of getting the speakers together, get everything submitted on time, things like that, and making sure everything was scheduled accordingly. So I thank Erin as well. And with that, I'm going to turn things over to Erin, who will get the program started. So here you go, Erin.
Hey, thank you very much, Bob, and welcome. I am Erin Jordan. I'm the Vice President of AFI and have worked with many of you and many of our speakers and sponsors to bring this 2-day AFI town meeting into existence, albeit virtually. I'm pleased to see that we've got a good set of participants and speakers today, and hope that we'll be gathering in person for this type of event in the very near future. Today, as Bob said, is day 1 of the 2 days we have planned. We hope that you make the most of this information and have a little fun during the day reconnecting with some of your friends. We have 4 speakers lined up today, each an expert in their own right. And we also have a comedian scheduled during one of the breaks, so stay tuned for that as well. I'd like to introduce our first speaker. She's a good friend and a resource to AFI and is a perfect way to start this year's town meeting. Dawn Hines comes to us from FDA, where she serves as the Division Director of Division of Northeast Imports. She and her team are charged with ensuring the compliance of FDA-regulated products entering our country through airports, seaports, and international mail facilities from Maine to Virginia. Dawn joined the FDA in 2002 and has served in many capacities. She was the Director of Investigations Branch for the Atlanta District, managing the domestic and import operations across FDA-regulated commodities. That was in North Carolina, South Carolina, and Georgia. Dawn's firsthand account of how the FDA has adjusted during the pandemic today will give all of our food importers a good view of the changes brought to the industry. We welcome Dawn Hines and want to remind you that Dawn will be live here with us during the presentation and also for questions immediately following. If you have questions or comments, you can put them in the chat room or wait till after the presentation and type in your question and I'll present it to Dawn. If you'd like to ask her question personally, you can do that too, just by indicating that by raising your hand or putting in the chat room that you'd like to speak with her directly. So I'm starting off the AFI town meeting, and I hope you'll help me welcome Dawn Hines.
Hi, my name is Dawn Hines, and I am the Division Director for the Division of Northeast Imports for FDA. Thank you so much to AFI for inviting me to present at this year's event. It is one of my favorites, and although we can't be together in person this year, I applaud AFI for putting together this event remotely. Let's get started. So as always, I am giving you current guidance and information. However, things do change, so please ensure that you are verifying that the guidance is correct and accurate when you go to use it in the future. I wanted to give you some news, and for us, this is big, exciting news, and that is that we have an updated compliance branch structure. Anna Alexander is our Director of Compliance Branch, and up until about 6 months ago, she was supervising all the individuals herself that were listed on the screen. And that's just too many individuals for one person to manage, especially when we have some great ideas for process improvements and productivity improvements. So we were able to add 3 supervisors to our team, and they are now going to directly supervise the compliance officers. So if you have a concern or a question about a compliance officer and you'd like to speak to a supervisor, you would reach out to Christy, Tanya, or Samantha, and the supervisors that they directly oversee are listed on the screen. Please be advised that the same structure is also in place in the other import field divisions throughout the country. You can contact them for the names of the compliance supervisors and who they direct. We also have something new and exciting, and that's how you get in touch with us. I know one of the complaints that I've had, and I know I've heard complaints from industry, is that our website was very clunky on how to figure out which office is handling your entry. We've updated our map just a few weeks ago. Let me show you. So the first thing you will see is a blue box that will direct you to ITAC so that you can go ahead and query your entry number to determine the status of it. You don't have to contact your customs house broker. You can look up the status yourself. Here you actually have a map where you can individually select a state. In the past, you would have to click the map. It would bring up a PDF of the entire division in which you would have to scroll down and find the state and the port of entry that you were looking for. Now you can click the state directly. Since we normally meet in New Jersey, let's check out New Jersey. You will see that it's covered by Division of Northeast Imports. And you will see once again that blue box to go ahead and check the status of your entry. You will see if you are importing through one of the courier hubs, DHL, FedEx, UPS, maybe you've imported some samples, some smaller shipments, and you're using one of these couriers, they have a different coverage map. You would click this map found here to determine which office handles that particular entry and that port. For questions, if you aren't getting as much information as you need from ITAC, you can click here to get entries under review. That will send an email directly to us. If you have a general inquiry on how to import a specific product, if you have a question about a regulation or you need more information about an FDA program, you can click there and that will send you, give you the ability to send us an email. It will tell you which offices in New Jersey are covering those particular ports. So you can see here, New York, Newark, Perth Amboy, and Morristown Airport are all covered by our Port Elizabeth office. And of course, the ports in southern New Jersey are covered by Philadelphia. It gives you the contact information for both of those offices. Now moving to what have been the impacts of COVID-19 on FDA import operations specifically. And the answer is not much. You are still receiving the same level of service and the same admissibility decisions as you had pre-COVID-19. So since the beginning of the pandemic, we have continued to work on site. Our consumer safety officers are out in the field daily conducting exams and sample collections of high-risk food products, other FDA-regulated products, and a whole lot of COVID-19 prevention and treatment products. We have been actively working at the airports, seaports, and warehouses in our division, looking at many fraudulent COVID-19 products, taking action against both those products and the importers, and referring those even for criminal action. So we have been busy. We are not stopping our regular routine work of surveillance. We are continuing it. We are also out still doing refusal verifications. The compliance officer refusing your entry will let you know what will need to be done. We are also going into the office and printing and mailing our FDA notices of action. However, it is on a reduced service. In the Northeast, we are currently going in twice a week to print and mail out notices of action. We are asking importers to please use iTax when you can. And I'm also going to give a plug for iTax account functionality in a few slides. A lot of our operations have shifted remotely, but with no disruption in service. The first one is entry review. These are the individuals who make that first admissibility decision after our electronic screening system does its job. So they're the ones determining if a product needs to be sampled or examined, if a product will need to be reviewed by a compliance officer, possibly for a detention and refusal. Speaking of compliance, all of our compliance officers are working off-site. Our management teams are working mostly off-site. However, we are going into the office from time to time to interact with our teams and to take care of some administrative activities. We are also conducting FSVP inspections remotely, as well as filer evaluations. And filer evaluations, for those that may not know what they are, we do audit customs house brokers and determine if the data entry, the entry data that they transmit to us electronically via ACE is accurate. So speaking of iTax, we are asking importers and customs house brokers to consider signing up for iTax account functionality. So iTax does have regular functionality that anyone who has an entry number can use. You can use it to query as well as submit documents and cargo locations for exam to us. It's very helpful. We're asking that everyone do this because we sometimes have to rotate staff in and out. We prefer that you use iTax instead of sending emails directly. You can also sign up for iTax account management. You get all of the same regular iTax functionality, but you can receive notices of action electronically. Where we've gotten feedback from importers and brokers is that this gives them a tool to not have to have someone in the office to check the mail to receive their FDA notices of action. They can get them electronically and they get them faster and can react to them faster than if they were relying on the paper notices being delivered by the U.S. Postal Service. We think this is a great functionality. We're looking at other options to add to this account functionality in the future that would give you the ability to communicate with us more directly. We haven't started initiating anything like that yet, but we are asking for people to consider an iTax account. We're also doing something a little different for our import inspections. As I just mentioned, it's the importer or the broker who provides us the notification that cargo is ready for exam, you're ready for FDA to come out and look at the product, either at a third-party warehouse or your own warehouse facility. So a lot of times we may give you a courtesy call to say, hey, is it okay if I come at 8 o'clock or 9 o'clock tomorrow morning? Other times, if something is very perishable, we may get out there right away and we won't do the courtesy call. Now we are doing the courtesy call, but we're asking for a little bit more detailed information. The CSO will ask questions about if there have been any COVID-19 positive employees or presumptive positive employees in the past 14 days. What type of prevention procedures do you have in place, such as temperature checks upon arrival and departure? Do you have a safety officer? Things of that nature. We're also requesting 6 feet of social distance between us and your team, as well as mask wearing compliance by your employees during our visit. We are still having our CSOs report back to us that people in the warehouses are not wearing masks properly or not wearing them at all. So we do ask for our safety as well as the safety of your own team that employees are complying with mask wearing. As I mentioned before, we are temporarily conducting FSVP inspections remotely. This is something that was, number one, asked for by industry. I know I received several requests from importers in March when we were starting up with hearing about COVID-19 and then the pandemic was declared. Several importers asked for this to happen. And we realized that this is a record review. It is not necessarily, we're not going out to look at a physical product. We are not going out to look at a manufacturing process or employee practices. We are doing a records review. We're reviewing an FSVP. We are not doing anything that would require us to physically be on site. So we came up with a remote protocol, and we started using it in early April. And we sent out this constituent update that I have actually copied and pasted the hyperlink to on this slide. What will happen is the CSO will contact you either via phone or via email to inform you that they will be conducting an FSVP inspection remotely on your facility. They will give you a demand for records document, which will tell you exactly what documents they are looking for, and they will walk you step by step through the process. After they've reviewed all of those records, they will schedule a closeout meeting in which they will tell you what their findings were and issue you a 483 if they do find those findings. So these are how we're conducting these right now. We've gotten very positive feedback, especially in the Northeast. There have been a few reports of some issues, and it's been on the western side of the United States, where some firms are questioning if it's FDA really contacting them. Please keep in mind that all of our employees have a .gov email, and you can always contact us to ask if this employee is one of our employees and is conducting an inspection of your facility. You're free to do that. I also wanted to point out some additions to our dashboard. So we've had this FDA data dashboard up for a while. I've always plugged this search firm information section where you can look up any facility and a lot of the information. Remember, it's supposed to be a FSMA data search, but it works for any FDA regulated facility in which we have data. We have added an import summary and import refusal tab, which are really nice. So this has refusal, exam information, sample information, product information in general. But what's really detailed is the refusal data, because this is refusal data from fiscal years 2002 to 2021 that you can download if you want to, sort it and view it. And it includes the product, the manufacturer's name, the address and FEI number, the entry number, if samples are collected, which division the shipment entered, the refusal date, and the charges. This information is staying up on our website. We have always listed out our refusal data. We have just now increased some of the information, more information ever than before. And I've gotten questions from importers already. Can I have my data pulled down? we figured out what the problem was and what caused the refusal. Can we have it removed? No. A refusal is a final action, and this data will remain on our website. And importers can use this to search and look at the history. You can see this for yourself, for your competitors, however you'd like to use it, but it is available as the government is trying to be more and more transparent on our activities. We also continue to update our FSMA dashboard, in which there is an import FSMA dashboard that lists both recall information for imported products and FSVP inspection data. So as I have told this particular group for quite some time, we issue a lot of 483s for FSVP inspections. As you can see from this graph, since we started the program, we have now 62.1% of our inspections have resulted in at least a 483 issuance, and we are starting to issue quite a few warning letters and adding importers to Import Alert. So we are still seeing a lot of importers who are failing to comply with FSVP. We hope that this trend changes course and that importers take this a little more seriously. But if you have any questions about outreach and education on FSVP, you feel that we need additional outreach and education, please let us know, and then we can take that back and see if we can get more for you. And that's it for updates on FDA for today's session. Thank you so much for participating, and I'm looking forward to your questions.
Thank you very much, Dawn, and thanks for being here for that presentation. I see you are live in our chat room. If anybody does have a question for Dawn to answer right now, you can type it into the chat area, or you can raise your hand and I can try to unmute you, or maybe Ed will unmute you. I do see someone's already asking for a copy of this PowerPoint presentation, and yes, of course, almost all of the presentations will be available from AFI after this meeting. And Dawn had made a note too that she was going to make that available to us. I'm wondering if anybody has any other questions they want to put in this chat area for us for Dawn. I have one that came in here. Dawn, are you there? Can you hear me?
I can. Good morning, everyone.
Thank you. That was great. I really appreciate your help with that. I'm sure your job has been made even more complicated during these crazy COVID times.
It definitely has, but we've responded really, really well. I think that really our import team has stepped up to the challenge. A lot of these PPE and other products are imported, so we've had a heavy lift. But I think that we really have accepted that challenge and have done extraordinarily well. I'm very proud of my team.
I'm glad to hear that. That's how it seemed from your presentation, for sure. I will ask you this one question. Would the FSVP be repeated for the same company that has already complied once or twice? And then
it could, yes. And the reason why is if you are importing a wide range of products, we only generally will look at your FSVP for 3-ish products per inspection. So if you import a wide range of products, we may inspect you more than once. Of course, if you had a 483 on your first or second inspection, you will be expecting another visit from us. So that's giving you an opportunity to look at the 483 findings and make corrective action and try to correct that, because we will be looking at it again.
Okay, thank you. Here's another one for you, Dawn. About how much time will importers have to provide records once notified of a remote FSVP inspection?
Generally, we give you a few business days, up to a week. That's the general time frame. If you're having difficulty converting things digitally, you can request a more time. Remember, this is not the time you should be putting together your FSVP. It should already be put together. So really, it's just a matter of getting it put together digitally and sent to the investigator who is doing your inspection. But, you know, if you make a reasonable request, we'll do our best to accommodate it and to work with you.
Very good. Here's another one for you. Since it'll be tough to do in-person inspections of foreign producers in the short term, do you know if the number of FSVP inspections is expected to increase?
It was already scheduled to increase. As we are doing and rolling out FSVP over the past, we're on our 4th fiscal year at this point, we are increasing our number of inspections every single year. So that was expected to increase. The one thing that we are doing is if we had a foreign inspection that was scheduled to occur over the past 8 months or so, we are increasing the frequency of sample collections or exams, especially the first or second time that they're importing the product. We're really looking more at physically examining, and we are using FSVP in that regard as well. When we can't do an inspection, we may do a targeted FSVP inspection for importers that are using that particular supplier that we had scheduled for a foreign inspection or where a foreign inspection is needed.
Okay, very good. Thank you. Here is another one. How long does the process of a remote FSVP inspection take?
It can vary, and it really depends on how many records that you're going to be providing during the FSVP. It can take anywhere from a week, a few days, a week, and I've seen them drag on for 2 or 3 weeks, just because we try to work with companies. We're being more flexible now, knowing that you know, you're under a lot of pressure and stress. So we are taking our time to do it. Also, we sometimes, unfortunately, have to pull staff if we have an emergency. We're doing a lot of work with COVID-19 products, of course. So if we have to pull someone while they're working on your inspection, we do that from time to time. It is not our normal practice. We like them to start something and finish it before moving on to something else. But sometimes we have to pull them away if there is an emergency and something needs to get inspected right away. You know, that does not, you know, have anything negative to do with the inspection, but since we're not interacting with you face to face and we're not sitting in your facility, we will not have, it should not have any negative impact on importers. I know it might be a cloud hanging over your head, but it's no negative impact. It doesn't mean the longer we take that it's bad.
Okay, that's good to know. Here's one. Is there any current change in the rate of sampling right now versus pre-COVID? And there's a second part to that question. What are FDA's areas of greater concern right now, either by commodity or origin?
I would say that our rates of sampling have actually dropped a little bit over last fiscal year compared to the previous one, just because we were doing so many exams of COVID-19 related treatments, therapeutics, diagnostics, and prevention products. So obviously we have this a few more people than we did the previous fiscal year, but we were doing a lot more exams related to those products. So our food sampling went down a bit. We will continue to do surveillance, and remember, we're taking the risk of the product into consideration. Our screening system, Predict, is built on looking at the risk of the product, the manufacturer, the inherent risk of the product, the importer's history. We're looking at those things. So our samples are based on risk. We're looking at that, and we're trying to look at the riskiest product. So really, your FSVP should be kind of telling you whether we're going to be examining something or not, depending on what the risks are identified in your plan. So ready-to-eat foods that have an inherent risk or a risk associated with the process, products that have the potential to be contaminated with antibiotics, we're looking at that. Any sort of food product, like I said, that's ready to eat, we're looking at those things. So, you know, I think it's something that, you know, the riskier the product you import, the more you're going to possibly have it sampled.
Okay, that makes sense. Thank you, Dawn. Here's another one. Would CTPAT certification reduce the frequency of FSVP inspections?
No. Unfortunately, CBP system for CTPAT does not coincide with ours. The only place where CTPAT actually does come into play is if that importer applies for VQIP. that is a requirement for VQIP, is to be CT-PAT certified.
Okay, that makes sense. Another question, is the FDA still doing on-site audits of foreign suppliers?
On-site audits of foreign suppliers. You mean overseas? I have to look. There were a few inspections that were directed last year. I do not believe that they were in the food arena unless it was done by our foreign teams in country. So the foreign teams that sit in China, or they sit in India, or they sit in Europe, or in South America, in Mexico. So I don't believe we did many foreign inspections just because we were under the same travel restrictions and trying to keep our teams as safe as possible. Let me know if I didn't go down the right route of that. I will answer it for FSVP. We have done some on-site FSVP inspections since the pandemic was declared, and it's mostly involving when we have an outbreak. It's traced back to an imported product. We will do a for-cause FSVP inspection, and due to the nature of needing documents immediately to trace that back, to get supplier information, to get your traceback information, a lot of times we'll decide to do that FSVP on site. I know we've done that in one instance in the Northeast where we needed documents very quickly in order to get a handle on that outbreak and to get the product recalled quickly, as well as to assess the foreign supplier's process as well to determine the hazard and potential causes of the outbreak. So you will see that from time to time. If an importer would like an on-site FSVP inspection in lieu of the remote, you can request that as well if it's too difficult for you to do a remote. We will look at that and determine if we can do it or if we need to postpone it.
Thanks. There's a question here. Maybe you know how much the fees are for VQIP.
They are still in the $13,000, $14,000, $15,000 range. Remember that it is a fee, a one-time fee for that fiscal year. It is not based on the number of products that you import. We are looking at VQIP. We only have 3 approved VQIP participants for this fiscal year. So we're looking at that program again, determining why we don't have as many participants. Is it the cost associated with you preparing all of the information that's necessary? Is it you're not feeling the benefit from it? So it's something, if you could give us feedback on really why more people aren't applying for it, that would be helpful to see if we need to tweak that. Remember that Congress gave us the directive to set up a program. They didn't actually prescribe exactly what VQIP had to look like. So we can possibly look at what we can do to modify that to get more interest and more importers interested in it.
Okay, good. Yeah, we would be happy to help with that if we can. I have one last question now, unless any more come in while we're talking. Someone's also asking about common errors or shortcomings in the FSVP inspections.
It is still the same. We walk into approximately 40 to 50% of importers and they have nothing. A lot of them haven't even heard of what FSVP is. They say, FSV what? So when we contact them, a lot of them still don't know that the program exists and what is required of them. So we are educating, but we are taking action. We are no longer in the educate while we regulate phase. We are in full regulation. So if you don't have a plan the first time, we will come out and do a reinspection. If you don't have a plan the second time, you're getting a warning letter. You don't have a plan the third time, you are going on import alert for those products that we did the FSVP inspection on. So it is in full regulation. We are, using our authority and adding a lot of importers to import alert, and we've issued dozens and dozens and dozens of warning letters for importers that are now in the queue of possibly being on import alert if they didn't take corrective action. I did get a private, I see the same message from Michael Lieberman. That data is on that dashboard I showed. I'd have to look it up really quickly, but there are a lot of 483s that have been issued, a whole lot. There is one asterisk I have to put on that particular dashboard, and that's the OAI, meaning our highest, most critical violations, that no FSVP at all. For last fiscal year, meaning 2019, 2020, and now 2021, some of those inspections are staying open because we're now taking action against them. So they won't show up on a dashboard necessarily, but they are there in our inventory. So that dashboard's a little deceiving on the top end of OAI inspections, but there's a lot of data there that's a little disturbing.
Yes, I can imagine. Okay, so I have one last question for you, Dawn.
Sure.
Any thoughts on the smarter era of food safety and the upcoming traceability requirements?
Yes, we have really been involved in this quite a bit because we are seeing a lot of actions starting to happen as a result of import sample collections and now thinking of the now what, so what. We are now putting an onus back on food importers. When we find a violation, we are now not just looking at that shipment saying, guess what? What has happened before that? Were there shipments around that time that we now need to consider? And importers now need to think not just shipment focused, but really what caused the problem? What have I imported prior to that? Do I have a potential risk on my hands? And traceability is going to be extremely important in this. You're going to see probably a lot more recalls on the import arena coming up as a result of our sampling. I know we've seen quite a few even this year with us not doing quite as many samples this year, but you're still seeing them because we are thinking now we have an opportunity, we know there's a violation, where did that occur, and is there product in the United States that could potentially be contaminated? So that's a little food for thought for this group.
Very good, Dawn. As always, as informative as you could be. You're an excellent resource to all of us, especially during these kind of crazy times. I do have a little bit of feedback for you offline with your question about the VQuip. Some people are commenting on maybe why you haven't gotten the response to that you were expecting. I really
okay, excellent. Yeah, and keep it coming. We'd love to hear from AFI and try to address that and to take all of your concerns about the program into consideration.
Well, we appreciate you, and if there's anything that we can do to help, that's always something that we welcome. Thank you for doing this today. Your presentation was excellent and informative, and I'm sure very helpful to our attendees and our members. As I enjoy seeing you. I think Bob Bauer would like to be unmuted before we go.
All right, well, I did unmute myself. Dawn, thank you so much. We really do appreciate it. And one of the key points for all the attendees that I heard, that always jumped out at me, was FSVP is ongoing. It's not something where FDA tells you today we're coming on Tuesday or we want the documents Tuesday, and now you start trying to produce them. You need them as you go along for each and every one of the products you bring in from each supplier. So from what I've seen, AFI members are doing a bang-up job in terms of when they've been inspected. So we hope that continues, and we see no reason why it shouldn't, because you folks have taken the initiative to make sure you are in compliance. So great step there. But again, Dawn, thank you so much. It's always a pleasure to have you speak, and the information you provide is crucial, and it really helps our folks stay up to date on what's going on and helps them to comply, which we know makes it easier on everybody on both sides. So thank you again.
Thank you, Dawn. It was great to hear you. We're going to be moving into our first break. But first will be our interactive portion of the AFI town meeting, and this one is a geography guessing game. Ed, behind the scenes, will be unmuting everybody for this short break, and we will be seeing some areas of the world and taking a guess at which place it is. So I think we're still muted. Ed, are we ready for the geography bee? You can guess where that is.
Cambodia.
Guess
Cambodia, Angkor Wat.
Very good.
Thailand.
Turkey.
Tangier, Morocco. Morocco.
Kareem, did you get that? Kareem, did you get that?
Close enough.
Kareem guessed it. Kareem guessed it.
Lawrence.
That's a little easier. That was an easy one. That's a little easier. That was an easy one.
Ponte Vecchio.
London.
That's
London.
easy.
That's an easy one.
Scotland.
Ireland.
Ireland.
Anybody know where in Ireland?
Moors.
The ring of
Where?
Cliffs.
that's south. That's the ring of Kerry.
No. Turkey.
Yeah.
Is Turkey. Anybody know where?
Yeah, whereabouts?
Antalya, Izmir, Malatya.
Izmir.
Really? China.
Vietnam. Indonesia.
Vietnam.
Vietnam.
Yeah, where in Vietnam?
Cambodia. Chicago, what is that, Chicago? Chicago, what is that, Chicago?
It's a city in Germany.
Oh.
Hamburg.
Cologne.
Cologne.
Munich.
Montreal.
City in Germany.
We're ready for the answer.
Frankfurt.
Frankfurt.
Spain.
Sevilla.
Italy.
No, Sevilla.
Seville.
Spain, yeah, Sevilla.
Go ahead with the city in Spain.
Toledo.
Toledo.
Ohio.
Ohio.
Hong Kong.
Hong Kong.
South America. Never been there. South America.
Rio. Buenos Aires.
Colombia. Mike say Rio.
Brazil.
Rio.
Rio.
Wow.
That's tricky. Bergen, Norway.
Curacao.
Agnes, is that you?
Yeah.
Exactly.
Impressive.
Cologne.
That's Cologne.
Cologne. Oh, how many times you walked that bridge?
That's right, huh? This one's easy for this group.
This is Africa, I think.
Africa's right.
Well, I would say
One for Kari.
Mozambique. Mozambique.
Hey, everybody, just wanted to say hello. Michael Coughlin here.
Hi, Mike.
Hi, everybody.
Tanzania.
Paris.
Paris. Oh. Before the fire burned.
Right.
Oh, Switzerland, I think I would say.
Morning, Howard.
Hey, good morning, Mike.
Austria.
Greece.
Let's try the Dolomites.
Cayenne, Spain.
Oh, what is it called? Meteoras. Oh.
Newark.
Anywhere in the world.
Elizabeth, New Jersey.
Singapore.
Newark.
Really?
Close enough.
That was fun.
Hi, Howard.
Hi, Agnes.
Hey, the turnout here is pretty impressive.
Good job, Aaron.
How's it going, Aaron? You're on mute.
Hello, I'm sorry, I was dropped. I thought maybe everybody was lost. Finished with the geography bee. I want to thank Coughlin Insurance Services for providing that grade. And we're going to be moving into our next speaker in just 5 or so minutes. Back with Brendan Judge.
Hey, if somebody has their phone on, you're going to get a reverberation. I think that's what's happening.
Yeah, I think so. So those who would like to, like we said, we have a few minutes, so we can chat it up and, but for those who would like to, feel free to stretch your legs and all that. We will look to start right around noon. I found out something interesting last night on Facebook. My nephew posted that he, his wife, and 3 kids are moving to Cologne soon.
Where?
Cologne, Germany.
Cologne.
Oh, really?
So I haven't had a chance to follow them up, but I think I have a place to stay in October.
Yeah. Excellent. We'll join you.
Right.
Good morning. I just wanted to say hi to everybody. And
Hey,
thank you
Jeannie, how are you?
for including me.
Hey,
Our
Jeannie.
pleasure to have you, Jeannie.
Great to see your faces.
Oh, Jeannie, hi. Thanks for being here today. How are you?
Good, doing fine. It's the teenagers who are starting to revolt. But my parents are still, behaving more poorly than the teenagers. So it's a matter of relative behavior here.
Right.
Yeah.
Oh, nice.
I do feel bad for the younger people. I think they had more of a big fun life to lose.
Yes. Although my eldest was in Manhattan and their campus had 0 cases from mid-August to, Thanksgiving, which was great.
That's great.
There are places where good things can happen. We just have to keep rolling and keep following the rules. That's the problem, right?
Yeah.
Yeah.
And my son will be able to get down to UPenn in January. They may open up, but he's been remote. And having a college kid around him.
It's pretty annoying, isn't it?
Well, when they come downstairs and he's got a man bun on, he's got some funky shirt on, some baggy shorts, black socks, and sandals, I have to go to work. I don't even want to comment.
Oh, that's good.
You kidding me?
You don't have a dress code at your house? A uniform?
You know what, Jenny? That's a good idea. I like it.
Yeah, but Mike, you might never meet it.
Yeah, well, yeah, no, that's a whole other thing. How are you doing, Bob? How's your family?
Thankfully, everybody's doing well. Everybody seems happy and healthy, and that's all you can ask for right now.
This is starting to get old, real old.
Well, hell, yeah.
Do I have permission to take a picture of all of you?
Make sure.
How do you do that?
Okay, we're coming up on 11:55. I think we can move ahead of schedule just a little bit. Do you think so, Bob?
Okay, then we might take a little bit longer of a break a little later, just to, we just want to make sure we don't start too early on like the last presentation if somebody comes in just for that. But yeah, I think we can go ahead with the next one and we'll go from there.
Okay, so let me take a minute to introduce our next speaker. Brendan Judge chairs the Commercial Litigation Practice Group at Connell Foley. It's a regional law firm headquartered here in New Jersey. I'm getting some feedback. I wonder if not everybody's muted. Ed, could you help me with that and mute everyone else? Brendan is an experienced litigator and focuses primarily on banking, commercial, and construction litigation. He also serves as national counsel for insurance clients in banking-related cases, as well as general counsel for multiple construction companies, where he manages all of their litigation needs. Brendan represents clients in contract, intellectual property, UCC fraud, and product liability issues before various federal and state courts on behalf of public and closely held corporations and national banking associations. Brendan was asked to speak today to address the ways in which our members can avoid or minimize commercial liability. This is an important topic for all businesses. Remember, Brendan will be joining us live during the presentation to take part in the chat group if you have comments or questions. And then immediately following, he'll be available to answer your questions personally, either through the chat room, on email or text to me, or you can raise your hand and we can unmute you so that you can ask Brendan your questions directly. So I introduce now Brendan Judge.
Hello, my name is Brendan Judge and I'm with the law firm Connell Foley. We're headquartered in New Jersey. The next portion of the program, I'll be addressing avoiding or minimizing commercial liability. So let me just share my screen and we'll get started. Okay, you should all be able to see me. Now, just a brief overview of what we'll be doing today. I want to address potential liability to third parties. That's liability to your vendors or your customers. Then I want to get into employee embezzlement. An awful lot of money is lost to employee embezzlement through check fraud, payroll scams, purchase schemes. And then I want to address briefly returning to work amid the pandemic. This is obviously a hot topic and a fast moving topic in today's world. But I want to go through some of the guidelines that you have available to you and also some potential legal issues in terms of your liability. So first, let's talk about liability to third parties. The first point I want to make is that you never, ever want to enter into an oral agreement. There's a great illustration of this issue in the 2016 film, The Founder, in which Michael Keaton plays Ray Kroc. And the scene I'm about to play you a snippet from is when they're at the table about to sign the contract and an issue comes up with regard to one element of the deal that they have to make an oral agreement over. So that begs the question, did the fellows get their full royalties? And I guess since we're playing the clip, you can guess that they did not. And this is the point where if we were live, I would ask for a show of hands, is that oral agreement enforceable? And the answer is, it is enforceable. And had they enforced it, they would have gotten what amounted to over $1 billion in royalties. But the problem was they didn't have it in writing. So although it was enforceable, there are issues with that. How do you prove what was agreed to? You essentially have a swearing contest. And also, there's the issue of the disparate resources. How are the two McDonald brothers going to take on Ray Kroc and all of his legal resources to prove that they had an oral agreement to get that 1% royalty? So really, the heartbreaking part of this deal, from my perspective, is that this lawyer committed the worst malpractice ever as he sat mutely, letting the brothers shake hands on that deal. So let's get into what it is that needs to be in writing. Now, just want to introduce you to the Uniform Commercial Code. The Uniform Commercial Code, as you can see, is a comprehensive set of laws governing commercial transactions, including the sale of goods, that have been adopted in most states. Every state has their own laws, but the states have strived to agree upon a set of uniform laws with regard to commercial transactions. As much as they strive to be uniform, they are not. There are variations, so you need to check a particular state. But what I want to address in the UCC is the statute of frauds. The statute of frauds relates to contracts that need to be in writing. Certain contracts are not enforceable under the statute of frauds unless there's a writing signed by the party against whom enforcement is sought. And there are a number of exceptions, but I think for our purposes today, I just want to bring your attention to contracts for the sale of goods of $500 or more, contracts between merchants, if confirmed in writing within a reasonable period of time, unless objected to within 10 days, and specifically manufactured goods for a particular buyer where those goods are not suitable for sale to others. Now, I would expect most of your transactions fall into this middle item between merchants if confirmed in writing within a reasonable period of time. So what is reasonable? Under the UCC, whether a time for taking an action required by the UCC is reasonable depends upon the nature, purpose, and circumstances of the action. So kind of, even though you have a writing in this case, you end up like the McDonald brothers where you have to prove something outside of the contract. In this case, the nature, purposes, and the circumstances of the action. Also under the UCC, an action is taken seasonably if taken at or within the time agreed to, or if no time is agreed, within a reasonable period of time. Again, that gets into the particular circumstances unless it's agreed to in writing. So again, we go back to the importance of having a written agreement. Now, another area of the UCC where you end up getting into proving facts is the course of performance, where a contract for sale involves repeated occasions for performance by either party with knowledge of the nature of the performance and the opportunity of objection to it by the other. Any course of performance accepted or acquiesced in without objection shall be relevant to determine the meaning of the agreement. So what does that mean? If you have repeated contracts with a particular customer, and let's say it's your practice to inspect those goods, not within 10 days of receipt, but let's say 30 days of receipt. And an issue arises after several transactions where you inspect after 15 days, and then there's a problem, and then the seller says, no, you should have inspected within 10. You can point to the course of your performance with that particular supplier in the past to establish that the reasonable period of time is actually more than 10 days. So what are some of the key components of a written agreement? As this cartoon illustrates, it's expensive to hire a lawyer to negotiate and put an agreement in writing, but I can't underscore enough the importance of it. Like here you see the contract is a couple pages, the bill for the fees is a stack of papers. If I were drawing this cartoon, I would put a third stack right about here, and it would be about 5 times the stack of the legal fees for drafting the contract, and that would be the litigation fees that result when you have a fight where you don't have a written agreement. So you want to save that big stack, and I recommend you incur the cost of that small stack. Well, let's get into some of the components. What you want in a written agreement is a clear description of the subject matter. What is being sold, what service is being offered. You want the dates of performance, the place of performance, and payment terms. You also want to consider a limitation on damages. Under the law, there's 2 types of damages. There's direct damages and what's known as consequential damages. Just by way of example, if you were importing, let's say, some bananas, and your buyer didn't end up delivering them, and you had to go and spend an additional 10% on the open market to get that same set of bananas to sell them, your direct damages would be that 10% difference between what you agreed upon and what you had to go out to market for. But there's also consequential damages. Let's say you had a great deal to sell those bananas and you were going to make a 50% profit, but you lost that deal because the supplier failed to deliver. The consequence of that failure would be your lost profits. And that can be exponentially larger than your direct damages. So in any contract, you want to consider, do I want to make sure I'm limited, I'm not on the hook for somebody's consequential damages, and then you got to think about what the other side may require. The next item is an integration clause. An integration clause means that everything that's been agreed upon is within the 4 corners of the written agreement. If you say, like the McDonald brothers, well, but we had this separate agreement on the royalties, if you have an integration clause, then that's not enforceable, because the integration clause says unless it's in this contract, it's not enforceable, with some exceptions, of course. You also want to consider choice of law, especially in your business, you're importing, you want to select the law where you're located to apply rather than some foreign countries. Same with a venue selection. If there's a fight, what courtroom, where are you going to be in court? Do you want to be in court in Singapore, or do you want to be in court in the United States in a particular state? The next provision is attorney's fees. In the United States, the lawsuits are governed by what's called the American rule, meaning if there's a lawsuit, each side bears their own attorney's fees, unless they put in a written agreement that one or the other side shares the attorney's fees. It can be fee shifting so that the loser pays, or it can be just one-sided. If you breach my contract, you pay my fees and enforcement. So it's definitely something you want to examine, both if you're adding it to yours or to make sure that you're not unilaterally on the hook for the other side's legal fees, because that gives the other side great leverage in any lawsuit. Automatic extensions in service contracts. This is something I see a lot of litigation about, where there's a service contract, say a communications provider. There you have a term for 3 years, and there's a small provision in there that says it will automatically renew for another 3 years unless you opt out within, say, 60 or 30 days before expiration. And a lot of companies, they sign the contract, they get the service, they don't like the service, and they decide to use somebody else, but they fail to put the other side on notice within that option period, and they end up on the hook for an additional 3 years. So just be careful about automatic extensions in any written contract. The next component I want to address is jury waivers. I am a big proponent of jury waivers. As you can see here, and as you know from your life experience, nobody likes to serve on a jury. But if you do get dragged down to the courthouse, at least you're hoping it'll be a celebrity trial, or at least a criminal trial or a personal injury trial where there's some human drama at issue. Well, take my word for it, in commercial litigation, there is no human drama at issue. You're asking the jury to read a contract and determine whether some party is entitled to consequential damages. Nobody wants to do that. And as a result, if you look to the other cartoon, juries are unpredictable. They are always unpredictable. But in the commercial setting, where the jury may not want to do the work to read the contract, analyze the different parties' positions, you never know what you're going to get. Whereas with a judge is trained in the law and is being paid to read the contract and apply it. So you get a much more predictable outcome. Another component in a written agreement is an alternate dispute resolution. You can decide, rather than sue each other in court, we can either require or offer each other two types of resolution short of a lawsuit. There's mediation and arbitration. Mediation is when you hire a private mediator. Oftentimes it's a retired judge or an experienced lawyer to sit down with you, and that mediator is not going to decide the case. He's not going to say who wins or loses. What that mediator does, will listen to each side and try to bring the two sides together where they can reach some sort of settlement. Now, arbitration is different. Arbitration is more like a lawsuit, a kind of a private lawsuit where you hire, again, oftentimes a retired judge or an experienced lawyer to act as your private judge, and that judge will make the decision. So I recommend in every written contract you include some sort of alternate dispute resolution procedure, and I do recommend arbitration through the AAA, the American Arbitration Association. Why? Pretty much because the alternate is a lawsuit. Lawsuits are extremely costly, and understand it's what I do. I do litigation, which is it's mediation, arbitration, and lawsuits. But it is costly. It's a very slow process, especially now in the COVID environment. It's also very disruptive for the businesses. It drains the executive time, and it is tremendously intrusive. What do I mean by intrusive? I got another clip for you here. It's old, but it's important.
What's all that?
Trotta's files, all of them.
You stole his files?
I didn't steal his files. Listen to this. I'm just ready to finesse him. I'm starting to finesse him, right? I got him going. He offers to have his secretary copy everything for me.
That's very impressive finessing.
That's not all. He's letting us use his hunting cabin as soon as he gets back. It's in the woods. It's quiet. He sleeps like a baby when he's there.
Terrific. You're a hell of a bondo.
What's this? You reading this book?
Yeah.
Do me a favor, okay? Don't read this book. Okay? Thank you very much.
All right. Don't you wonder why Trotta gave you his files?
I told you why already.
He has to. By law, you're entitled. It's called disclosure, you dickhead. He has to show you everything, otherwise it could be a mistrial. He has to give you a list of all his witnesses. You can talk to all his witnesses. He's not allowed any surprises. Didn't teach you that in law school either?
Okay. That's a great clip, obviously, from my cousin Vinny, Marissa Torme, and Joe Pesci. But it is important in any lawsuit. Now, my cousin Vinny was a criminal trial, and the civil litigation has slightly different rules, but essentially you have to disclose everything. And what does that mean in terms of your documents? You have to disclose every relevant non-privileged document. Now, in 1992, when my cousin Vinny was filmed, which was the year I first started practicing law, what did that mean? It meant you get the banker's box like Vinny just had, and you'd go through those hard files. In a big case, maybe there were 20 of those. Now, what drives discovery is electronically stored information. All your emails, all your instant messages, all the metadata behind them, everything. So it turns fairly simple commercial disputes into very expensive, intrusive undertakings because we get everything. And we hire consultants to go in, image your server, and pull out the privileged documents, but everything relating to the lawsuit is going to be turned over to the other side. And what's the problem with that? The problem with that, especially in this world of electronic communications, is people are not as careful in their emails and their texts as they would be if they were writing a letter. Now, this is an actual email in one of my cases involving, it was a fraud case involving a product that had a fire prevention component. And in this, two people in the same company, William and Carlos, are communicating. William says, Fire Department of New York will not accept the test results on the old product. They're too old. The FDNY will require current test results. Bill says we should continue using the original certification number. Additional testing would be expensive and time consuming. Let's draw the line on some of this regulatory BS. Well, this document, when I find this from the other side, in my case, this is the smoking gun, because I'm trying to prove that Bill is engaged in fraud. He's willing to lie. Here he's willing to lie on something as important as a fire safety device. So I knew I had him in this case. But more importantly for his company is if there was ever a fire as a result of that particular product and there was a personal injury action, this would then amount to a criminal case. So you want to be very careful in terms of what you put in your emails, what you put in your text, what you permit your employees to put in their communications, because lawsuits are intrusive, and the same applies for arbitration. So let's move on to embezzlement by employees. You see here this triangle, essentially the psychology of fraud. Somebody's given an opportunity, they're put in a position of trust with regard to your finances of your company. They are under pressure. There's some sort of financial pressure going on, and then they rationalize. Well, I'm not paid enough. I didn't get the bonus I wanted. I've handled over 150 cases in which employees of companies have engaged in embezzlement through these types of schemes. It's simple theft, there's purchase scams, payroll scams, check fraud, wire transfers. The most frustrating part is the check fraud. The businesses are behind the times. Over 80% of the U.S. households bank online. That may be even higher now. But the U.S. companies still cling to writing the checks. Over 50% still pay their bills by check. Normally, I would ask for a show of hands. 50% of you would raise your hands that you still pay bills by check. Now, there's benefits to e-payments versus paper checks. The only reason I've heard somebody express with regard to holding on to paper checks is it gives you a few extra days of liquidity, but I think it creates some tremendous problems. In 2019, over 14.5 billion transactions involved checks between businesses. While checks are projected to become obsolete by 2026, I suggest that for your company, you make them obsolete in 2020. Now, when an employee engages in check fraud, you figure, okay, the bank has my signature card. They know what my signature looks like. It's the bank's obligation to make sure the check is not paid, that I didn't sign, so I'm not liable. Right? Wrong. Not necessarily. The bank certainly shares some liability, but the customer has a duty to discover and report. The liability depends upon the type of fraud and the company conduct involved. Now, forged makers, that's where the signer of the check on the front of the check, the employee forges that signature. And it's a liability according to each party's negligence. Did you fail to supervise that employee? Here's a big one. Commingling of accounts payable and statement reconciliation duties. The same person deciding who to pay is the person who is reviewing those bank statements at the end of the month to make sure everything matches up and making sure everything is proper. The company can be liable for negligent hiring or leaving their check stock unsecured. The important thing about this is there's a 1-year statute of repose regardless of fault. What's that mean? Well, if you don't bring a forged maker to the bank's attention within 1 year, you then lose the right to sue on that. And banks often put in their statement agreements, their agreements, what's called a cut down clause, which cuts that 1 year period down to as little as 30 days. So really, you want to make sure you're on top of reviewing your statements at the end of the month. If you give your signature stamp to an employee, then you're just done. The bank can just make sure that, or can ensure that you're entirely liable for that loss. There's also a rule in most jurisdictions under the UCC called the repeater rule, which means the act by the same wrongdoer. If you don't catch it within 30 days, and that same person does it 30 days later, 60 days later, repeatedly does it, once that first 30-day period passes and you haven't provided the bank notice, you're on the hook for the full amount. And that's a huge defense for the banks, because these cases involve the employees who will do it a little bit 1 month and then they'll get away with it. And then they'll do it a little bit the next month or a couple months later. And it just turns into years of doing it. And you can lose money like over the course of years. I've seen millions of dollars walk out the door and nobody knows it. Once it's discovered, the bank invokes the repeater rule. You should have let me know back years ago. So you're on the hook. Same thing with missing or forged endorsements. That's on the bank. The bank who accepts the check from somebody, they're on the hook for making sure that the person handing them that check is the same person. But you got to understand how many millions of checks are processed every day in the United States. Banks are unable to look at them all. So that the bank that accepts it will be on the hook, but they have defenses too. That your employee was faithless, that you shared in the fault and contributed to that loss. Electronic transfer fraud, the wire fraud, this is the same thing. It's an allocation of fault. But the problem with wire fraud is these losses are massive and immediate. But you got to bring it to the bank's attention because you have a statute of repose in that as well. Now, courts are less inclined to look at cut down clauses on electronic transfers. Payroll scams. I want to talk a little bit about payroll scams by your employees. Payroll padding is when an employee will increase the payment to themselves. It's a direct deposit every other week, and maybe they add 20%, and over the course of time, they've gotten 20%, and then they get raises on top of that, and you've lost millions of dollars. Payroll hijacking. Let's say an employee is taken off the books, moves on to a different company. Your account, your internal people may leave that person on the payroll and redirect those direct deposits to their personal account, and everything looks fine in terms of accounting, but that person is then stealing all that money. Now, if that's done by check, if there's a paycheck issued, in both cases, neither the maker's signature nor the endorsement are forged, so there's no bank liability for that. You're on the hook for all the loss. Let's go through some internal controls. You want to limit the number of employees with invoice approval, and you want to limit their dollar amount of approval. Now, this next point, I couldn't stress enough, this is worth the price of attending today. You want to segregate the accounts payable function from the statement reconciliation function. I can't tell you how many people have somebody trusted, maybe even a family member, that they have handling both these functions. And it's the person who is so trusted, and they never take a day off. And they never take a day off for a reason. It's because they don't want anybody to see what they're doing. So you need to make sure, if you do nothing else as a result of today's presentation, segregate your accounts payable function from your statement reconciliation function. You also want to require dual signatures on any checks over a certain amount. You want to require approval of expenses over a certain dollar amount. And you want to have periodic unannounced transfer of approval authority for invoices so that you can see what's being approved and have somebody else take a fresh look at it. You want to require a D&B report for all new and existing vendors. You want to require management to telephone the contact for new vendors, because you want to make sure this vendor is real. You want to require an annual management meeting with all vendors over a certain dollar amount. You want to perform data matching analysis to ensure that no vendor contact information matches your employee data. For example, a cell phone number. I've seen where that's been caught. You want to conduct background checks on your employees as well. National Crime Index, Federal Criminal Search Index, state and county criminal searches. Here's a big one. I highly recommend you get Fidelity Insurance. It protects business owners against theft of money, property through forgery or fraud by an employee. And the thing about Fidelity Insurance, they pay their claims. I've seen situations where, or we've all seen situations where an insurance company fights a claim. I think title companies have never paid a claim. Excuse me. But Fidelity companies, they come in, they'll take an affidavit from you swearing to what occurred, they'll pay you, and then they'll pursue the employee. So I highly recommend Fidelity Insurance. Who gets stuck with the loss with employee embezzlement? You do, almost invariably, unless you have the Fidelity Insurance. Again, over 150 cases of these sorts of things. Very, very few get jail time. Maybe 20 that I've been involved in got some jail time, the real jail time. One fellow did give me a tip, which I'll pass along. We deposed him in jail. He had embezzled about $300,000 from an elderly gentleman who he was caring for. And his tip was, don't ever confess, because he felt bad in the end and confessed, was arrested, and then got, I think it was over 7 years in jail. And his bunkmate embezzled like over $500,000, didn't confess, but his lawyer was able to plead him down. So this guy's advice from jail was, don't confess. I don't know whether that's the best advice. Quickly, I want to address returning to workplace in the pandemic. This has been such a world of upheaval, and it's really going to impact every company that returns. Now, when you do return, and who knows where this is going, what you need to do is go on the website for the Center for Disease Control and Prevention. It's a great website. It's a wealth of information. I could give you some of it now, but it would be different 2 weeks from now. They have segments on OSHA, preparing workplaces for COVID-19, preparing small businesses and employees. They also have workplace frequently asked questions, and it's a wealth of information. Suspected or confirmed cases in the workplace. What do you do if somebody's is suspected to be COVID positive? What do you do if somebody comes in and tells you that their roommate just tested positive? All that information is there. Also, information on reducing the spread of COVID in the workplaces, healthy business operations, cleaning, disinfection, and even limiting workplace violence. You also, in addition to checking the CDC's website, you need to check your state's executive orders. I just checked in New Jersey, Governor Murphy just issued his 200th executive order, almost all of which relate to COVID. So it's a developing situation. When you decide to go back to work, you want to check the CDC website and your state's executive orders. So what are the potential legal issues with returning to the workplace? What we're seeing now are what's called take-home cases, where employers are facing potential liability, where a worker gets sick from being on the job and goes home, or ends up just being positive, goes home and infecting people at home. Now, if the worker can establish that he or she got sick at work, then that's going to be covered by workers' compensation. but the family member is not. And we see that there are lawsuits working their way through the court system with regard to take-home cases. So what do you need to do? You need to make sure you comply with the CDC's guidelines. We're also seeing wage and hour violations. This is for the at-home employees for putting in more time for the non-exempt employees and not being paid for overtime. We're seeing discrimination claims by employees where they're brought back to work after a furlough, or maybe they're not brought back to work, or there's some sort of negative employment decision made, and they're claiming that it wasn't based upon COVID, but rather their protected status. There's also the issue of retaliation claims filed by employees who complain that the employer is not following the CDC or OSHA guidance in the workplace. Finally, there's interference claims filed by employees who may have been denied leave to attend to their own medical issue or to care for a family member under the Family Medical Leave Act, or which has been expanded by the Families First Coronavirus Response Act. Now, in some states, including New Jersey, if an employee provides medical documentation to support a COVID-19 related leave of absence, the company must provide leave for the period recommended by that person's healthcare advisor. Once the employee is cleared to return to work and is no longer at risk of infecting others, the company should permit them to return to work without any changes in the terms or the conditions of employment. To the extent you're considering terminating an employee who is on or has recently returned from a COVID-related absence, you can't base that decision in whole or in part on the fact that they were infected or took a leave of absence. You got to make sure you document the actual reasons for the negative employment action. Under the Family First Coronavirus Response Act, it applies to employers with fewer than 500 employees. It provides that you must provide 2 weeks regular rate sick leave for quarantine due to government or healthcare provider directive, and 2 weeks at 2/3 rate for bona fide need to care for another subject to quarantine, and up to an additional 10 weeks paid extended family and medical leave at 2/3 rate to care for a child whose school has been closed. Finally, with regard to the potential for whistleblower lawsuits, to minimize the risk of a whistleblower lawsuit and to increase the chances of defending it, you want to take these steps. You want to take a strong and vocal stance in communicating the company's commitment to following all applicable federal, state, and local guidelines relating to the health of employees. This is an important one. You want to actively engage employees who raise questions about health and safety matters. These are your potential future whistleblowers. You want to engage them, use them. What's wrong? What are you seeing? How are we non-compliant? If you engage them, they become part of resolving the problem rather than becoming a separate problem down the line where they file a whistleblower suit. And you want to swiftly and directly confront any employees who violate company health and safety policies and practices. Well, I tried to jam a lot in there, and I appreciate your time. The one takeaway is, as a dispute is brewing, you want to make sure you tell the truth, but George Washington got it absolutely right here. You want to talk to your lawyer first, because we're going to tell you to tell the truth, but we're going to tell you how. We're going to package the truth for you, tell you when to tell it who to tell it to. We're going to make sure that you're protected. So anyway, I hope you found this helpful.
Okay, thank you very much, Brendan. I can tell you that was an extremely comprehensive set of information that is beneficial to everybody that could hear it, whether or not you own a business, run a business, or interact with business people. That was extremely informative. I think you might want to consider being a more of a law school professor or teach more classes than you already do. It was very helpful. Brendan, I think you're here live with us today. Can you hear me?
I am, Erin. I'm live and I can hear you.
Hi, how are you today? Thanks for being here.
Sure.
We do have a few questions already. I've given instructions to everyone that if they do have a question for you, to put it in the chat group or to send it to me directly. So I have a couple from different various formats. We'll start with this one here in the chat room. The question is, can you use collateral agreement exception to the parole evidence rule to modify an agreement?
You can. Collateral agreement is a separate independent contract between two parties and oftentimes a third party that can be used to satisfy the statute of frauds, but that agreement itself is subject to the statute of frauds, meaning it may need to be in writing to be enforceable.
Okay, I think that was a full answer there. If you have any more questions on that, Kareem, let us know. I'll ask another question here. I want to talk a little bit about COVID and how that's affecting some of our contracts. First one here is, does the new COVID stimulus bill that Congress is considering now have any effect on the employer liability?
That's an excellent question, Erin. As many people may know, they're currently debating back and forth the form of another stimulus package. There's a number of points of contention as to the amount and the form of the stimulus, but there's also another major sticking point. The Republican legislatures have supported limiting COVID liability, which is designed to curtail lawsuits, those take-home lawsuits against businesses, schools, hospitals, and other organizations from people who claim that these institutions caused them to acquire coronavirus, except in instances of gross negligence. Now, the Democrats have balked at that plan. There's also a bipartisan movement to set a 6-month moratorium on coronavirus-related cases to give the individual states the opportunity to put in their own liability protections. So that's something that is a developing situation. I don't know whether there's a liability or a lobbying arm to your organization, but you may want to consider lobbying both Congress and potentially your individual states with regard to the potential liability protections.
Yes, that has come up with many of our clients because certainly it could affect many of our members and the way they conduct their business or coming out of this pandemic. So thank you for that. I have another question here. And again, if anybody has a question or wants to ask Brendan a question personally, you can indicate that by raising your hand or making a note in the chat room. Otherwise, this may be our last one. Yeah, this could be our last question. Sometimes we purchase through brokers, our food importers. On occasion, the supplier claims to know nothing about the contract and says the broker has no permission to act on its behalf. This person's asking if you have questions, suggestions on how to address this.
Yeah, you need to determine who the broker represents. The broker acts as an agent, and there's often a dispute as to whether the broker is acting as the agent for the buyer or the seller. And the problem with that is the agent can often bind the party. And I've seen it occur in arbitrated decisions where a broker binds somebody who never intended to be bound. So what you need to do when you're engaging in a broker, either your own broker or somebody else, you need to determine and make clear in writing in advance who the broker represents.
All right, I'm trying to see if there's any other. I did make a note before we started that the presentations will be available through AFI. We send them out with a survey as early as next week. And that your contact information for all of our members and attendees will be made available to them to follow up if there are more questions about this. Extensive contract information, especially now in our stage of pandemic. Brendan, I appreciate you being here today live and also for the pre-recorded presentation. Thank you for sharing your expertise with us on minimizing or avoiding commercial liability. Thank you.
You're very welcome, and thank you for the opportunity to present.
Happy to have you. Thanks.
Bye now.
We are rolling right into our next speaker, after which we'll have a break with sort of a funny interlude. Their next speaker is Jeff Para. He's a managing partner of the Northern California region for Markham LLP. He carries more than 25 years of experience providing tax, business, and industry advice and insights to all of his clients. Jeff uses his in-depth industry knowledge as the basis for developing and applying tax and value-added business strategies to customize for his clients. He has particular expertise in consumer and industrial products, including manufacturing, food and beverage, distribution, and retail. Mr. Para holds a Master of Science degree in taxation and a Bachelor of Science degree in accounting from San Diego State University. He has been published in numerous trade and business journals and is a frequent presenter at industry and professional conferences on various technical and industry topics. His pre-recorded presentation will be played now to discuss tax-saving opportunities for business. Unfortunately, Mr. Para isn't feeling well today and will not be able to join us live for a question and answer session. But if you have any questions, please email them to me at aaron@afius.org, and I'll be sure to relay the questions to Mr. Para and relay the answers back to you. His presentation will be available afterwards, so if you want to receive it, it'll be sent out with the surveys from AFI next week. So I give you Mr. Jeff Para.
Hello, my name is Jeff Para. I'm a partner with Markham in San Francisco, California. Here to talk a little bit about some of the tax planning opportunities that may come your way as a result of being in the food and beverage industry, as well as some of the new Biden proposals that may impact you as well. So we'll spend a few minutes talking about those opportunities and some of those ideas. And we'll also talk a little bit about some of the things that aren't on this agenda, but at the same time, you could be aware of in terms of talking to your current CPA or tax provider. And you can ask them about some of the things that I'll mention here briefly. So getting into the presentation, the first thing we wanted to talk about to you is the fact that we have a number of changes that went into place as a result of the CARES Act, which, as you may or may not know, was put in place as a result of the COVID-19 economic impact that it had. One of those is the qualified improvement property. It's a technical correction that has many benefits to food and beverage companies. Some R&D tax credits that many folks don't focus on, but are pretty much available to food and beverage companies, especially in the innovation area. We'll talk a little bit about the possible Biden administration tax changes that were part of the platform in his presidential campaign. And we'll talk about some of the planning considerations as a result of those exact proposals that he put in place. So with that, the first one is qualified improvement property. And this is a technical correction that was put in place just recently with the CARES Act. And basically, if you think about improvement property, let's say you're running a restaurant or you have a distribution center, or you have a number of different landing places where you've got your food and beverage type products. You may have made a lot of improvements to those properties in the form of leasehold improvements or improvements that are non-structural in nature. Well, before this CARES Act came in place, those additions would have had to have been depreciated over 39 years. This provision in the act came in place and said, you can treat that improvement type costs as 15-year property. And as a result of having it qualified as 15-year property, it's also now eligible for what's called bonus depreciation or immediate expensing of that property. So if you had a distribution facility and you put in a new road leading up to the facility, you put in some new walls, you put in some new HVAC, you put in some new structural, non-structural areas, those costs now can be expensed immediately. And that could be of great benefit to you because those costs that otherwise would have been amortized over 15 years under the new law can now be expensed immediately. Now, when you look at this and you say to yourself, gee, for the 2020 year, I made X amount of improvements that qualify for immediate write-off, you actually may find that it might have put you into a tax loss situation. If that's the case, another provision in the CARES Act was to allow taxpayers to carry that tax loss back 5 years and free up additional refunds that otherwise would have been paid or taxes paid in prior years. And those taxes paid in prior years were probably paid at a much higher rate, more likely 35% versus the 21% for the corporate rate right now. Or if you're an individual at a higher 39.6% rate versus the 35% rate that most individuals at the higher rates are paying. So there's a significant opportunity here. And we at Markham have found a number of companies, both in the distribution, manufacturing, some in the restaurant area, where they've made significant improvements coming back into January and February. Some even made more coming into May and June, thinking that we would come out of this sooner than we have in COVID-19. And now as a result, they've got many expense items that they now can take in the year, the 2020 year. And this creates this tremendous amount of saving opportunities for them. So that's a significant opportunity that we wanted to mention. Another one that many companies are eligible to take, but many just don't know, is the research and development tax credit. Research and development tax credit is usually associated with companies in the technology area, but research and development is really around companies who are trying to innovate, trying to eliminate uncertainty around how things work, whether it's two pieces of machinery that they bought from two different providers, and now they've got to work together to produce a new energy bar or a new drink, or maybe you're trying to eliminate the taste as a result of introducing non-gluten type ingredients into your products, or maybe it's a different type of drink from a CBD manufacturer and you're trying to sustain a good sweet taste without the introduction of additional sugars. So those type of experimentation, those types of understanding what will work or won't work as it relates to sustainability or packaging or processing the ingredients to make the shelf life sustainable in the areas of those where you're going to be selling the product, they likely qualify for the research and development tax credit. And that's a dollar for dollar reduction against your tax that you otherwise would pay. And so we've assisted a number of companies in the food and beverage area, even in the distribution of food and beverage, where the accessibility of certain machinery has laid way to the fact that they're now much more streamlined relative to less handling costs or human handling or touch costs. And that in itself is a research and development tax credit opportunity for you. So Markham can actually assist you with reviewing those costs, documenting the qualifying activities. We can calculate the federal and state tax credits that go with it. And then of course, file the tax returns that get you those credits and potentially even create and generate some new tax refunds and cash flow for you in the year in which you are going to generate those credits, and then of course take those credits on your tax return. So I would encourage food and beverage companies, whether you're on the distribution side, the manufacturing side, to ask your CPA or ask Markham for that matter, whether or not you do qualify, and all the compensation costs for the people who are engaged in those activities, as well as the supplies that you are using in order to produce those types of products, will qualify. And it's our job to help you document and then of course take advantage of those opportunities for you. Now let's get into, actually let me just make one other thing in terms of opportunities for some other company related matters that don't fall on this page in general, but some of the opportunities that many of the distribution companies fail to take advantage of are some of the slotting fees that many of the companies are incurring. And slotting, as you may or may not know, is the fee that you pay for your retailer to put your product on end caps or in eye level areas where customers are more likely to see your product. Now, there's some additional accounting methods that you can look at in terms of taking advantage of how you may take those deductions, and we can help you qualify some of those costs in a way that become more cash flow advantageous to you from a tax perspective. And a couple other areas that we see food and beverage companies not taking full advantage of is a deferral of income for gift cards. So even though you may give a gift card or sell a gift card for the production of services or products that haven't yet been delivered, you can defer the cash recognition of that income to a year after the year in which you received that cash if certain requirements have been met. And we can help you identify what those are. We can help you defer the recognition of that income. And in that regard, we can help you look at the 2019 year or the 2020 year and see whether or not you've over-included income in the year of the sale of a gift card, for instance. And it may qualify you for some additional refunds. So now let's go into some possible Biden administration tax changes. And here on the screen, we've got a number of bullets that you may or may not have heard of in the campaigns of the platforms of Mr. Biden and Mrs. Harris. But basically, these bullets capture a lot of things that may impact many of you on the webinar today, and you should be taking note of these. So I would invite you to print the screen and look at these items. But the ordinary income brackets for individuals with annual incomes over 400,000 will be raised from the maximum today of about 37% to 39.6%. And that's just the federal level. There's going to be other corresponding state impacts as well. The $400,000, if applied to joint filers, can impact those obviously in the 35% bracket. So you've got a lot of additional tax that you're going to have to potentially put aside from a cash flow perspective to take that into account. Many of you may run as a partnership or as an S corporation or as an LLC, taxed as a partnership, for instance. And for those who have annual incomes of over $400,000, they're actually proposing to eliminate the 199A business deduction. So that's the deduction that would reduce your 39.6% rate down to about 29.6% rate or 28% rate. So there's a lot of potential downside here that you need to be aware of. It also imposes a 12.4% Social Security tax on wages up to 137 and earned income over 400. So you're going to need to look at whether or not being an S corp may make more sense for you versus, say, a partnership. One of the other big things is taxes on long-term capital gains and qualified dividends, where they're currently taxed at no more than 23.8% in today's environment, will go all the way up to ordinary income rates for incomes over $1 million. So something to be aware of. And the last thing on this page is the corporate income tax rate will increase from a flat 21% to 28%. And if you recall, the reason the Trump administration put in the 21% rate was to attract much of the foreign investment into the U.S. And to make the U.S. more competitive worldwide, as well as just lower the tax cost for U.S. companies who are operating here in the U.S. So some of the planning considerations as it relates to this, and I should just note too that these are just proposals at this point. As many of you may have heard or now know, there are two Senate runoffs going on in Georgia right now. The two Republican senators, should they win, will help the Republicans maintain control of the Senate. And much of what I'm talking about now in terms of these considerations may or may not take place if, in fact, the Republicans retain control of the Senate. And if they do retain control of the Senate, then many of these things may not go into place. But if they don't, and or if it's a 50-50 tie, the vice president, who's a Democrat, would cast the deciding vote, and much of what this is in terms of these proposals could actually become law. So it's important that you look at these things and ask your CPA to give consideration to how you might do some planning opportunities between now and the end of the year, recognizing that the runoff doesn't occur till January 5th, but you want to be in the best position possible between now and then to make whatever changes you can. So some of the planning considerations that we came up with, and there aren't a lot at this point because we didn't want to go down the road too much of being very detailed, but we did want to give you some ideas of what you might consider. So for long-term capital gains and qualified dividends, right now, as I mentioned, they're taxed at 23.8% in the current year. So you may want to accelerate as much of those long-term capital gains and qualified dividends this year, because next year under the proposed law, they would go up to ordinary income rates. And so to the extent that you can have them taxed at 23.8% versus ordinary income rates, you're going to come out ahead. If you're thinking about selling your company, or you may want to sell a portion of your company by monetizing some portion of it, this may be the year to do it, because again, as the first bullet just mentioned, you want to accelerate as much of the income in 2020 to avoid the higher ordinary income rates in 2021. Likely, you'll want to defer some of the deductions that you otherwise have from 2020 into 2021. So as an example, as many of you may or may not know, for bonuses to be accrued and deducted, they have to be fixed and determinable by the end of the year and can still be deducted if paid by March 15th of 2021. Well, if you don't want to make that large accrual deductible in 2020, merely make it non-fixed and determinable. In other words, you don't yet know what the amount's going to be, and you don't pay it by March 15th of the following year. And thereby you can put that deduction of compensation or bonus into 2021 when the tax rates are at a higher level, giving you a bigger tax break. As I mentioned before, you also want to look at accelerating income in 2020, because the rates right now under the Biden plan will be lower in 2020 than they would be in 2021. And then the other thing that we think is worth your time and effort to at least consider over the next 2 or 3 weeks and into the first part of January is to really reanalyze your choice of entity for your business. Does it make sense now to be a C Corp? Because 28% is going to be lower than the new Biden rate of 28% is going to be lower than ordinary income rates if you're taxed as a partnership with incomes over a certain amount. So you really want to look at all the options in front of you. As you know, state and local tax deductions are limited to $10,000. And as an S Corp, you're paying, and as an individual shareholder, you're paying state and local taxes. And those taxes as an individual are limited to $10,000. But as a corporation, they're not limited. So maybe being a C Corp and looking at the analysis between being a C Corp and an S Corp from an after-tax cash flow standpoint makes a lot of sense in terms of how you position your business going forward, especially coming out of COVID-19, where most economists are forecasting significant GDP growth as the vaccine comes off into the larger population for businesses and individuals to take advantage of. So I hope that was helpful for all of you, and I would love to answer any of your questions. There's my contact information. Markham is a national firm with more than 30 offices and more than 1,500 individuals working at Markham. And we would love to entertain any questions you have. And thank you so much for spending the time with me today, and hope you all have a great rest of the day. Thank you.
Okay, well, our thanks go out to Jeff Para. As I mentioned, he isn't feeling well today and isn't able to join us live for questions and answers, but I will take any questions that you have for him. If you want to email that to me at aaron@afius.org, and I'll get those questions to him. Now I'd like to take a minute and turn it over to Bob Bauer, the president of AFI, to cover a couple of topics affecting AFI and our members right now. And then when we come back, we'll go to a fun and entertaining sort of break. Bob, you're there? You ready?
I'm ready. Thanks, Aaron. So prime example here of why we had the speakers record their presentations ahead of time. So thankfully, we were able to get the information that Jeff was able to share with us. And as Aaron said, if you have questions, send them to her, and we'll get it to Jeff and others at Markham and get answers back to you. I did want to cover a few things happening in and around AFI. And so I'll take a couple minutes to do that now, since we don't have the Q&A that we had scheduled. So traceability is a word that I wanted to make sure that you become more and more familiar with. There is a new proposed rule. It's all part of FSMA. It's dealing with traceability. We're still learning a lot about it. FDA is going to do, I think, another really good job, as it's done with everything else with FSMA, in terms of sharing information, receiving comments, and that sort of thing. So we will keep you informed about, what is going to be needed. But you definitely want to be thinking that in your mind. We knew it was coming, and one of the big clues we have is that the associate director for foods within FDA, Frank Giannis, came on board 2-3 years ago, formerly with Walmart. But since he got in there, traceability has been mentioned by him over and over again. So we knew when this new era of smarter food safety was being talked about, that it was going to lead into something regarding traceability. So I just wanted to bring that up to you, so you get in the mindset that you're going to have to be able to trace where your products are coming from. So if, for example, you're not using lot codes yet, you want to start moving toward that right away, because you will not be able to comply with that regulation. And quite frankly, it'll be tough for you to comply even with FSVP without having a lot code system. And then, of course, God forbid you ever have to do a recall. If you don't have a lot code system, you're going to have to recall all of your products, so that the expense could be enormous. So good segue actually over to FSVP. I was on a webinar this morning. I actually had to get off before they got into some stuff that I wanted to hear about. But it was put on by the Food Safety Preventive Controls Alliance. So that's the organization that put together, it's a public-private partnership with FDA, that put together the training sessions. Many of you have taken it through AFI and with myself as an instructor. So we're getting updates, and the FDA speaker was speaking. So I'm just going to look at my notes real quick that I was taking in that, because I found it pretty interesting, a couple of things here. Here are the numbers on the FSVP inspections, and I think go by fiscal year, which starts October 1st through September 30th. So it was kicked off in 2017. They did 280 FSVP inspections in fiscal year 17. And 18, it got up to 785. In 19, it got to 870. And fiscal year 2020, which just concluded, they did 1,238. The goal has been 1,325. So they still, even in spite of the pandemic, got 90% or so of what they had intended to do. So you could see the numbers going up. And I was the one who was asking the question when Dawn was on, if there's any insight as to whether that number is going to go up this year related to COVID, because they can't do the foreign inspections. And I hope to have an answer for you guys soon, and I'll put it in the next newsletter, because they're coming out with the plan for this fiscal year, and I think it's going to go up because they can't do a foreign inspection. By inspecting you, the importers, they're kind of de facto doing an inspection of the foreign supplier. So since they can't go there, why not increase the number that they're doing here? So I'm thinking that's going to be the logic, but we'll confirm that as we go forward. I was looking over the roster of who's on here, and I think all or almost every company represented here has taken the FSVP course through AFI, if not through somebody else. So I commend you for that. If you've only had one person take it, I recommend you do another, just in case that person leaves the company or is out sick or on vacation when FDA comes to do an inspection. Another thing I got on there, the foreign inspections. They were increasing those as well. So in fiscal year 2018, it was 900, and it's either 903 or 983. I was writing in a hurry. 2019, it increased to 1,273. And they were going to look to bump up that number a little bit, but then the pandemic hit and they were only able to do 549 foreign inspections in fiscal year 2020. If things go well this year, they might get up to that number again. But as you heard Dawn say, you know, they're still limited in what they can do there. There's something called a RRA, Remote Regulatory Assessment. And what that deals with, it's if somebody was inspected and there were some issues, not huge issues, just some minor issues most likely, you're going to have the opportunity. It's a voluntary request made by FDA. Do you want to do a remote regulatory assessment? And they'll ask you for updated paperwork and stuff, and ask you to demonstrate where you've improved upon. So that is something to consider. And, you know, obviously, if you've taken the steps to address anything that FDA pointed out to you, you want to prove to the agency that you've taken their information seriously, you've acted on it, and now you are in compliance for two reasons. One, just to be proactive, show that you mean business, but then also to lessen your chance of an inspection. If you don't participate in the voluntary program at RRA, your chances of inspection are going to go up because, as Dawn mentioned, the inspections of importers for the second and third times now, the ones who are being inspected are the ones who had shortcomings the first time around. So those of you who had everything and seem to be in order, your chances of an inspection are less. Again, it depends on the types of product you bring, how many different types of product, but in general, your chances are a little bit less in an FSVP inspection than somebody who had issues in the past. And the same is going to be held true for foreign producers and domestic producers for that matter too. It's all risk-based and history-based and that sort of thing. In terms of, FDA is serious about increasing FSVP inspections. They want 560 of their folks trained to do them by the end of fiscal year 2021. So that would be 75% of the people in their import program. And just to remind you, that before an FDA inspector can come to you to do an FSVP inspection, they have to take the FSVP course that you take, should you choose to, and then they go for an even longer course internally. So before they can do an FSVP inspection, they've had a week of training essentially on FSVP. So their goal is to have 560 trained personnel in there. I know just a rough estimate for me, north of 100, probably 120-ish of the FDA inspectors have done the initial training through AFI's offerings. We're talking about a fifth of the people haven't taken the course through us. So, which I find great because they get to interact. Those who are taking the course now have another contact at FDA, but you see what they're like, they see what you're like, and it's been a great move by FDA to make sure people were taking that course. So now I just wanted to give a quick update on some other AFI type issues. The MTB, the miscellaneous tariff bill. That's where we look to get temporary duty eliminations, reductions, et cetera, on product that's essentially not produced here in the United States. Every 3 years we go through this process. So we're at where we normally are at this point. All of our work's been done, everybody else, all these thousands of petitions that are on this huge bill, everybody did what they needed to do. There's just one group that hasn't, and it's the Congress. So we don't know when that's going to happen. There's a lot of pressure being put on. As you saw, there was a letter sent by a coalition doing that. And again, I thank the members who agreed to sign on to that. It's tough to say. I'm not all that optimistic that it's going to pass by the end of the year. And then we'll have to see how they treat it next year. But Nicole Bivens Collinson from Sandler, Travis, and Rosenberg likely will address some of that tomorrow in her presentation. And I know she's also going to talk about tariffs, so I'm not going to mention that. But perhaps if there's anything I want to add after she's done, I'll do that at some point tomorrow. GSP, another item I know is important to a lot of members here. Same thing, you know, this is a really important week. You know, we're part of the coalition for GSP, so you know we'll forward that information on to you when we get it. But I got something from them this morning saying this week is key. They're not too optimistic if it gets passed this week that it's going to get passed this year. Same with the MTB. We just don't know if it goes into next year whether or not there'll be retroactive treatment. So I wish we had some more solid information we can give you on that, but we don't at this point. Quickly on facility renewal, AFI does hundreds of them, and they're all moving along pretty well. We do recommend that you, the importers, check with your foreign suppliers to get confirmation from them that they have renewed their facility registration, because you don't want the product to show up here and not have a valid registration for the facility. So I recommend you take that step to ask them. And the new wrinkle this year, foreign facility needs to have a DUNS number. And as predicted, it's backed up right now. So there is a workaround that we're not sharing yet with the foreign members because we want them to get that DUNS number, because you can still get it. As we get toward the end of the year, we're not going to let folks, you know, not be renewed because they didn't get their DUNS number. We'll do what we have to do to get that through, but we're really pushing them to get the DUNS number. If they start panicking with you, today's the 8th, they have to the 31st. There is about a week time frame to get a DUNS number at this point. So it'll be somewhere around the 10th, the 15th or so that we'll start going that other option in terms of making sure the renewals get done. But in the meantime, we want to encourage them to get the DUNS number, because they're only going to have 90 days to correct the issue if we go that other route. So most of the members seem to be doing pretty well, but you definitely want to reach out to your foreign suppliers, make sure that they're all set there. And then a couple things kind of internally, we want to make sure that you're all familiar with the workings of AFI and how your membership works. All right, so it's a company membership, so everybody at the company could take advantage of, you know, the resources that we have. We the best way to do it, if you need help, just send an email to info@afius.org. But you set a username and password, and there's one person who is the administrator, and that person could go in and add and delete employees at any point. And the folks that are staffing info@AFIUS can help you do that. But it lets you control the information that's sent to folks at your company, and who gets what and that sort of thing. And it's the best way to keep us current. And we always recommend that you have a few people getting the information in case you're not there. And we do ask you to update it on occasion, just to make sure that the information is still current. And it leads me into the last thing I wanted to bring up for now. And that is, if you haven't already, you will receive shortly the information that we need for the AFI annual publication. It includes a directory of members. So we send you a copy of the listing that we have for you, and we ask you to confirm that, hey, it's okay as is, or here are the changes we want to make. And please don't assume that we're able to remember that so-and-so left the company, because it's different people working on this that may not have seen that or may not have known that person. So that's why it's crucial that you provide that information to us. We're looking forward to another interesting annual publication, and you know, we'll We're moving towards sort of a hybrid where it's going to be even more of it will be available in an online version, including the membership directory. And so we want to make sure the information is as current as possible and as valid as possible. I know there was a question in the chat, so I want to answer that one real quick. So how far back is minimum for traceability? At the moment, the general rule of thumb supposedly is one up, one back, but the way the regulations are written, I don't interpret it that way. I already interpret it as traceability going all the way back, because if you're buying from a foreign supplier, they have to have a supply chain management program in place that says, where you're able to prove that the ingredients were safe when it got to them. In order to do that, they have to go back pretty much all the way to the farmer who produced it. So the traceability rule will make that, I think, more clear than it is now. But that's the goal you should be shooting for already, is traceability all the way back, so that you'll have a leg up in complying with that regulation when it comes into play. So with that, I will turn it back over to Erin to introduce the next segment, and we'll go from there.
I am here. Can you hear me? You can. Okay. Well, I will shift gears now for our first interactive and fun break after several sessions of informative content. Our next speaker is a comedian brought to us by the sponsorship of Suntech Transport Group. It's time to have a little fun and laugh a little bit at our Zoom lives on work and personal. Tim Lee is a comedian who's here to tell us or teach us a little bit about the ways we manage and maximize our Zoom activities. Please enjoy a couple of minutes to laugh with him before we move ahead to our last speaker. Again, we thank our sponsor, Suntech Transport Group, and we welcome comedian Tim Lee.
If you haven't muted your microphone, please take the opportunity to do so. My name is Tim X. Lee. I have been brought here as a scientific authority on video meeting technology. I am a Zoom meeting expert. Someone muted my microphone. I didn't know you could do that. All right, well, please don't do that again. To conduct effective Zoom meetings, you must understand the 80-20 rule. 80% of the people are only listening 20% of the time. Now, I'm going to have to repeat that 5 times so 100% of you hear it. What is the most important thing in Zoom meetings? The most important thing is to look important. How important and how do you look important? Important questions. Let's start with how to look important. There's things you can do to look important in a Zoom meeting. Number 1, take control of the screen. When you take control of the screen, you're taking control of your future. Number 2, if you're showing a chart, say the data comes from an impressive source. That credibility gives you credibility. Casually mention a meeting with a high-level executive. Make sure everyone understands you're on a first-name basis. You're in the big leagues. Now, at this point, I'd like to take control of the screen. What we're looking at here is a very interesting study. It's a study of the number of Cheetos consumed versus the number of cats in the house. It comes directly from a 2020 Harvard University study of foods marketed with a cat to cat people. Now, one of the more interesting things you will notice is that there appears to be no relationship between the number of Cheetos consumed in the house and the number of cats until you get to 3 or more cats, at which point the Cheeto consumption drops off a cliff. A very puzzling result until you factor in that Cheetos is a food you eat with friends. And people with lots of cats have no friends. No one comes to visit them because their whole house smells like a litter box. Now, I was having lunch with Bob Bauer. Bob and I meet up a couple times a week for coffee just to discuss the direction of the company. And Bob had an interesting take. Bob says, you know what you're not looking at here, Tim? You're forgetting that Cheetos is marketed with a male cat. And maybe it is that tomcat that is frightening all the cats in the house. Now, I'm not someone who sucks up just to try and get promoted, but Bob, that was an amazing interpretation. You were operating at the next level. Another thing you're going to need to know to be successful in a Zoom meeting is you are going to need to know your audience. Here's some tips for understanding your audience, what they do and what it means. If they have a blurred background, that means I live with my parents. Beautiful scenery background, I wish I was on vacation. CGI background, I'd rather be playing video games. If their microphone off, if you heard how I really talk, you'd have to fire me. And camera off. Another tip I can give you to draw your audience into a Zoom meeting is make it about them. Make your presentation about the different departments within the company, no matter how obscure it is. Here's something about fuzzy logic, which is an alternative to Boolean logic. Boolean logic is the form of logic that's at the heart of our computer system. And Boolean logic says that every statement is either true or false based on the law of the excluded middle. You can either be a member of a set or not a member of a set, but you can't be both at the same time. Fuzzy logic is an alternative view that allows for things to be partially true. Here's an example. We can think of water when it's frozen at 0 degrees Celsius. It's 100% true the water is cold. But as that water gradually gets warmer and warmer, it becomes less and less true that the water is cold, and more true that the water is hot. This is how good of an employee you are versus how often you lie. As you lie more and more often, it becomes less and less true that you are a good employee, and more true that you are a good manager. If you lie too much, at some point your employees don't know what to believe, and at that point you have to move into sales. One last tip to make your Zoom meetings pop. Take whatever topic you're talking about and tie it to a personal story. Here's an example, electronegativity. This is a measure of an atom's ability to bind shared electrons. What you're looking at here is hydrogen chloride. The hydrogen and the chlorine share a single pair of electrons, but the electrons are essentially hogged by the chlorine atom because of its high electronegativity. I've discovered another property I'm calling blanket negativity. It turns out I married a woman with a very high blanket negativity. We go to bed at night sharing a single blanket, which is clearly big enough to cover both of us. But because of her high blanket negativity, at which point she does what I call the pig in a blanket maneuver.
Figure out?
Now, what if you're in the position where you can't take control of the screen? How can you make yourself seem important? Answer someone's question. It makes you seem knowledgeable. And the easiest question to answer is your own. Remember the 80-20 rule. 80% of the people won't even realize that you're answering your own question. Now, do I answer my own questions? No. No, I don't. Why don't I answer my own questions? I think it's beneath me. Should you answer your own questions? Yeah, go ahead. You might need to. Now, I hope you learned enough that you can have the same success with your Zoom meetings that I have with mine. Thank you for joining me.
Well, thank you, Tim Lee, for breaking up our very educational and informative day with a little bit of comedy about our educational informative day. Hopefully tomorrow when you hear more from Bob Bauer, he can share some of his firsthand Zoom mishaps over the course of the last 9 months, because that is also its own comedic moment. All right, so I hope you enjoyed Tim Lee, and I wish everybody had been unmuted so that we could talk a little bit more about him, but I will move ahead since we're right on schedule for our final speaker today. After 3 stellar speakers offering expertise, I want to introduce a 4th amazing speaker who's going to talk about Proposition 65. Sophia Castillo is a partner at Downey Brand, a law firm in California, and she's an environmental lawyer that helps her clients comply with, litigate, and figure out complex issues relating to Proposition 65, and also environmental law and toxic exposures in California. Sophia specializes in developing risk management and risk avoidance strategies, and in crafting regulatory compliance programs that are in line with those risk goals. Sophia is known for her excellent client relationships and helping her clients develop practical, common sense, and creative solutions to their most difficult problems. She has defended Proposition 65 claims for many years, representing clients in litigation, negotiations, and in building and implementing compliance programs. She did her undergraduate work at UCLA and received her law degree from UC Hastings College at the Law in San Francisco. She's a frequent speaker on Proposition 65, chemical and environmental law issues in California. AFI asked Sophia to present today because she has a particular interest and a passion for this Proposition 65, which is of extreme interest to our members. She represents many national brands, private label and institutional suppliers, and family-owned food processing businesses, as well as being well-versed in the nuances of exposure analyses that shape Proposition 65 compliance decision-making. Please welcome Sophia Castillo, who will cover the abundance of Proposition 65 claims, all related to food during this pandemic. Remember, Sophia will join us live to answer your questions immediately following her presentation. And you can ask questions through the chat room or ask to speak with her directly by raising your hand. So now I will welcome Sophia Castillo.
Hello, it is such a great pleasure to be here with you all today, and I'm delighted to talk about one of my favorite topics, California's Proposition 65, and how it relates to food businesses. My name is Sophia Castillo, and I'm a partner at Downey Brand. We're a law firm in San Francisco and Sacramento. What is California's Proposition 65? Prop 65 is one of the things that, frankly, makes doing business in California difficult, complicated, and different from the rest of the country. It is a law that requires all products sold in the state, including food, to bear a certain warning label with certain text if use or consumption of the food product causes an exposure to chemicals on a list maintained by the state. And this Prop 65 list contains over 900 chemicals, some of them which I'm sure you are unfortunately familiar, particularly acrylamide and lead, but also mercury, cadmium, and arsenic. Here's an example of the warning label for food. And as you can see, the text of this warning label is inflammatory. And for folks in the food business in particular, probably you do not want to put this warning label on your food. It describes that the using or consuming the product, in the case of food, can expose you to certain chemicals, which are either known to the state of California to cause cancer and or birth defects, or potentially both things. Now, the use of this warning label, as you might imagine, is incredibly common in California. So you see this warning label on lots of consumer products, furniture, electronics, appliances, almost everything that's sold in the state. And frankly, you do see it from time to time for food, and you see it used and placed on food. But in the food context, it's important because food folks, as you might imagine, do not consider putting this warning label on a food product to be good marketing. Why would you want to scare your consumers by describing that eating your product could expose your consumers to a chemical that might make them sick? And so because this warning label is so incredibly inflammatory, it helps us to give a little bit of context about why we're talking about what we're talking about today, and why it's important to understand. Prop 65 came to be and was brought into effect as a right to know law. That is, its sole purpose is simply to educate the public about when they are being exposed to certain chemicals. It doesn't require reformulation. It doesn't ban the use of certain chemicals like lead or acrylamide in California. It merely requires use of that warning label. So you might say, well, in other circumstances that aren't food circumstances, the label is what the label is, what the label is. But for foods in particular, this warning label is meaningful. The other thing that makes Prop 65 incredibly powerful, and the reason why it has gotten so much steam in California, is because the law allows private enforcers to bring claims against retailers and those up and down the supply chain for selling products in California, and to recover their attorney's fees in so doing. What that means is that a variety of citizen plaintiffs groups off the street can send you a letter initiating a claim, and if the claim is successful, recover their attorney's fees in bringing that claim. And as you might imagine, this has created an absolute cottage industry of plaintiffs' attorneys that love to send letters alleging Prop 65 violations. And we have an incredibly now robust plaintiffs' bar alleging that folks throughout industry in California, including the food industry, violate Prop 65 for selling a number of products without this funny warning label. Prop 65 is incredibly costly. Citizen prosecutors, these plaintiffs groups, bounty hunters, as a lot of folks like to call them, have filed more than 30,000 violation notices since Prop 65 went into effect in 1988. Litigating Prop 65 has cost businesses more than $37 million in settlements since the year 2000, and labeling requirements alone are expected to cost companies a great deal of money in the next decade, possibly upwards of $818 million. And these statistics are incredibly interesting and incredibly profound, and help to put Prop 65 into context. There was a really, really good and thoughtful article put together over the summer in the LA Times that collected data and provided a few incredibly neat vignettes about how Prop 65 is affecting the business industry in California. And these statistics were taken from that article. I would be happy to send it to you afterwards. Feel free to reach out to me or email me. And the article gives a really nice context and overview about what folks doing business in California are struggling with respect to this law. Prop 65 claims from 2012 to 2016 have largely focused on food and beverages. You can see that in comparison to clothing and accessories, furniture, and electronics, the food and beverage claims are quite far ahead and quite a lot more common. Prop 65 in practice for food. So what does this mean? The law sounds scary, it sounds overwhelming, and you must think, oh my goodness, how could I possibly figure out which of my products contain these 900 chemicals, and how on earth will I figure out if I need to put that warning label on my products, and why on earth would I want to do that in the first place? Well, as Prop 65 has evolved, it has turned into a question of risk and the importance of understanding the statute, and the low-hanging fruit, as it were, for the plaintiff's bar has driven industry's ability to manage that risk. What we see time and time again are that certain chemicals are targeted, in particular in the food industry. And the main chemical that we see quite frequently is acrylamide, followed closely by a group of metals, mostly lead, sometimes mercury, cadmium, and arsenic. And with respect to acrylamide, I'll talk a little bit later in the presentation about how California has proposed some refinements to the law to address the concerns related to the food industry with respect to acrylamide. I wanted to give you a little bit of a high-level overview about acrylamide and how we have seen this chemical evolve and take shape in the Prop 65 context. Acrylamide is formed when foods are roasted and browned. And you see acrylamide claims in, talk more about this in a minute, in crispy, crunchy snack foods. The more delicious, the more common acrylamide is. So French fries, chips, bagels, waffles, and even coffee. And I expect that some of you that are watching this presentation are well acquainted with the tremendous amount of drama that the coffee industry has suffered because it was targeted by Prop 65 plaintiffs. And so coffee beans themselves are roasted and browned. And in that roasted and browning process, acrylamide is generated, allegedly. Now, whether or not acrylamide actually causes a human to get cancer is, of course, scientifically up for debate, and we'll talk a little bit more about the science as well. But acrylamide has been an incredibly hot topic for the food industry for a really long period of time. Lead, mercury, and cadmium are also low-hanging fruits for the plaintiff's bar, and there are typically two groups of claims in the food world: the acrylamide claims and then the metals claims. And so you can see metals claims come up in a number of contexts, but historically they have been seaweed and seafood claims. And now plaintiffs are getting a little bit more creative and testing almost every packaged food for lead, which is a really interesting thing, and I'll talk more about in a minute. Typically, again, we see certain food groups that are targeted over the entire history of this law. We have the crispy brown snack foods, the more delicious the better. Those are hot acrylamide targets. Seaweed, seafood, chocolate, canned goods, vinegars, all of these groups of foods have allegedly had metals in them, particularly lead, sometimes other metals as well. So now we are getting to the nitty-gritty, which is how on earth do you comply with this law, and what does this law mean? Well, the law is not as simple as the plaintiff's attorneys would have you believe, because what we see with the plaintiff's attorneys is that they just go out and shop for products, test them for their favorite low-hanging fruit, sweet acrylamide and their suite of metals. And if they get a hit, they send a Prop 65 notice and allege a violation of the statute if you're selling your food without a warning label. Prop 65 is a little bit more complicated than that, because the crux of the statute is exposure. And that is, are humans, our typical California consumers, exposed to enough of the food product, even assuming that it contains the chemical, such that they ingest enough of a food product that they would exceed a threshold level proposed by the state and written on the Prop 65 list. And then the warning is required. So what this means, and as food businesses, and as you are working to understand the statute and understand the risk you have, is that consumption, dietary consumption data and typical consumption is really, really important to the Prop 65 risk analysis and to understanding whether or not a warning label is required for your product. So a hypothetical example, if you have a food product, lead is always a good example because it's kind of, it's a chemical that folks really pay attention to. If you have a lead product that maybe a sauce, and the product allegedly contains lead in some quantity, but it's a dipping sauce perhaps, or a type of sauce that is not consumed that frequently. According to Prop 65, if an average consumer, or California consumer in particular, is not eating the product that frequently, it could have a certain amount of lead in it, and the warning label would not be required. And so when we just wade into the funny morass that is Prop 65, it's not as simple as the plaintiff's attorneys would love for us to believe. That is, I bought your product, I tested it for lead, and it has way too much lead, you need to put the warning label on it. Actually, we need to go out and we need to look at consumption. We need to look at average consumption. And we need to understand if this food is really eaten enough, even if there is a chemical in it, that it needs that Prop 65 warning label. And so the statute, the law prescribes a math problem where out the back end, when you consider consumption versus chemical content of the product, you can figure out if the threshold level above which a warning label is required is exceeded. And when I start working with clients in this phase of their compliance process, a good thing to do is to get a food science expert that is well versed in Prop 65 to give you some advice here. So along with a lawyer, a food science expert will test your product, will know which chemicals probably would be in the product, and will be able to do that math to say, okay, well, if we look at historic consumption of this type of food product, we can see it's really not eaten enough, that certain trace levels of lead that may have made their way into the product are significant enough to require a Prop 65 warning label. And again, this is a technical science exercise that's driven by testing the product and analyzing the consumption of the product. So how does a Prop 65 claim from a plaintiff's attorney work, and what does it look like? Plaintiffs will go and buy food either online or in California brick and mortar stores. They will test the foods, and these are the typical low-hanging fruit foods that contain common chemicals if those products don't have warning labels. And if after this scientific testing, the plaintiffs find that foods do contain chemicals on the Prop 65 list, they will initiate a lawsuit process by sending a 60-day notice of intent to sue. And after receiving that 60-day notice letter, the law says that you have 60 days to talk with the plaintiff, try to resolve the claim. And if after that 60 days elapses, they may file a lawsuit. Companies respond in a number of ways. Some companies will negotiate a settlement that is either approved by a court or is out of court. And other companies may have their Prop 65 strategy well in place and say, I did a study with my food science expert, and I feel great about my study that my product doesn't need a warning label. And at that point, we'll negotiate with opposing counsel and we'll push back. And even if you haven't prepared a strategy or have a formal thought process in place upon receiving that 60-day notice letter, there's absolutely no reason why you couldn't test the product yourself and come up with an approach and a way to manage and to push back if that seems like the right thing to do, depending on the chemical content of the product. Prop 65 claims during the COVID period. This has been such an incredible time for the world and an incredibly bizarre time in the Prop 65 practice. And while folks may have thought that COVID would slow down plaintiffs' attorneys, maybe they'd take a break, lay low, spend some time with their families, what we have seen is that the plaintiffs' attorneys are out shopping and they're out buying foods. They are either buying foods online and shipping them to California if the foods don't have a warning label on them, or they're going into brick and mortar stores. And of course, the grocers have been open as essential businesses and just buying products that might contain Prop 65 chemicals and that don't have a warning label on them. And so we are seeing a lot of claims for metals now. Seafood claims have gone bonkers. Clams, cuttlefish, shrimp, snails, a number of pre-packaged seafoods that are in cans or plastic, sometimes marinated. Plaintiffs' attorneys are alleging that seafoods contain lead and cadmium. Seaweed is still going gangbusters. Some of these notices have been sent again. Others are new, alleging that seaweed contains a host of metals and these seaweed products require warnings. Canned goods are picking back up again. We're seeing plaintiffs' attorneys go out and test fruits and vegetables in cans, and they're finding fruits and vegetables contain mercury and lead. Vinegars have historically contained lead, and at the beginning of the COVID period, we saw plaintiffs' attorneys going out and testing vinegars again. And baby food, fruit puree pouches that all of our toddlers and young children need, we are seeing the plaintiffs' attorneys testing those again as well. And historically, there have been some baby food settlements and there's been some incredibly significant baby food litigation. The plaintiffs' attorneys are back at it. And dietary supplements have always come on the radar for plaintiffs' attorneys and relate to these allegations that dietary supplements have lead in them and need a warning label. Acrylamide has also been going gangbusters. We are seeing hundreds and hundreds of claims alleging that the acrylamide content of every tasty snack food you might imagine requires a Prop 65 warning. Crackers, chips, pretzels, popcorn, cookies, tortillas and tostadas, granola, bread, waffles, olives, and of course, nut products, including butters, particularly almond products, have been very, very popular. The state has taken stock of the incredibly voluminous amount of notices that are going out for acrylamide products and for our favorite crispy, crunchy snack foods, and has proposed a regulation that will make clear the levels of acrylamide above which a warning label is required. And this is incredibly helpful for those in the food world that may be receiving acrylamide notices for all of our favorite snack foods. And so this regulation has not yet gone into effect, but gives specific levels above which a warning label is required for almonds, breads, cookies, crackers, potato products and chips, prune juice, and waffles. And these are some of the most common food products that Prop 65 plaintiffs' attorneys will target by alleging that the products can't be sold without a warning label because of their acrylamide content. So, as someone in the food world, what do you do next? There is incredible sales advantage in understanding the trends and risks related to Prop 65 in California. For instance, companies that sell cookies, crackers, breads, and golden brown products are, for the most part, expecting to receive a Prop 65 claim at some point. And so for all of those folks in the food community and those attorneys in the defense bar that represent those companies, it's pretty expected and standard that if you do business with these products, you're going to receive a claim sooner rather than later. And while all of us are waiting with bated breath for the state to implement its regulation, giving us some certainty on those acrylamide levels, it's slow going. So companies doing business in this space are studying their products, understanding what acrylamide is in those products, and working up a strategy to defend those claims if allegations are brought that their products need a Prop 65 warning label. What does it mean to prepare generally? Well, you understand the trends. That is, acrylamide's a big one. If you're selling delicious snack foods that are crunchy and browned, think about it. Evaluate your products. Do you sell packaged seafood products that have really picked up steam in the eyes of Prop 65 plaintiffs? You might want to go back and look at those products and understand if there really is measurable metals content in those products. Could you be a target? Well, if you sell products that are on the lists of commonly targeted items by plaintiffs' attorneys, you could be. So if you are a target, undertake an exposure analysis. Understand if you really might need to warn. If you're selling a product that has an awful lot of lead in it, maybe you want to put a warning label on. Maybe you want to consider reformulating so you don't have to put a warning label on. Maybe you can zero in on where that lead is coming from. I have had clients that sell products and have isolated lead content to a certain facility that manufactured a certain batch of the product. They're able to reduce the lead content fairly significantly by shipping to another facility and having another facility package their products, or going to another supplier of a flavor or a key part of their product and working with that supplier to ensure that what they're buying and putting into the final food product doesn't contain, for instance, a lot of lead. We are seeing that there are certainly and have historically been types of food products that, when purchased from upstream suppliers, can contain lead. And as folks are becoming more and more educated on Prop 65, the entire supply chain is working together to eliminate or reduce the lead content so as to avoid Prop 65 risk. And retailers even are becoming hip to the Prop 65 world, even smaller retailers now, and are requiring Prop 65 certifications. That is, they are having their vendors and upstream suppliers certify that a product meets Prop 65 or that a warning isn't required, and that if a lawsuit or an allegation of a Prop 65 violation is received, that the upstream supplier will indemnify or defend them in that claim. In conclusion, what do we do about Prop 65 in California in the food world? First, there is tremendous competitive advantage in California business by monitoring Prop 65 trends and risks and having a Prop 65 and strategy in place. Retailers are requiring it regardless, so it's a good thing to do. And to do it, understand your products, understand whether they are common targets of Prop 65 plaintiffs, test those products if necessary, and have a plan if you receive a claim. It has been such a great pleasure to be here with you today, and I welcome any emails or phone calls and look forward to talking with more of you in person throughout the program and in the future. Take care.
Thank you, Sophia. That was excellent and certainly on point and timely for our AFI members doing business in California. I think you've joined us live. Is that true?
I'm here. Can you hear me?
I thought so. No, I can hear you. Thank you. Thanks again for that pre-recorded presentation. It was excellent. And I think we do have a couple of questions since we have a minute or two here. Let me just pull this up. Here's a question for you, Sophia, if you can hear me. If a product contains a Prop 65 chemical, is it easier just to put the warning on the label? And from your experience, since so many products, food or not, have warnings, do consumers really pay attention to those warnings?
So that I would say is a common compliance strategy, and some people do that. And so I would say I see smaller businesses in particular use the warning label placement just as a strategy and a way of complying. And because Prop 65 itself doesn't require you to reformulate, it just requires you to put that label on your products if your products contain a chemical in a measurable enough quantity that might exceed that threshold label. That is a perfectly acceptable way to comply. If you don't want to use the label, and if the label is off-putting to you, that becomes a fork in the road and a way and a place for you to get some competitive sales advantage in California by understanding, using lead as an example, how much lead is in the product, and if you really do need to warn, depending on, for instance, average consumption of the product by the average California consumer. As to the question whether or how common those labels are, I mean, I'll be honest with you, while the coffee industry, using them as an example, was in the middle of their extensive litigation battle and also their extensive lobbying and regulatory refinement push, I saw labels everywhere in downtown San Francisco near my office building at every single coffee shop ever. I mean, anyone from Starbucks to the small local roasters and in between. And in terms of foods, what I'm seeing more now, because the coffee industry was successful in pushing back on acrylamide and now has a carve out in the law, because their efforts were so fruitful in that regard, their lobbying in particular. What I see now is that some of the smaller food purveyors will have the warning label, and for the most part the larger folks will not, because they have the money to invest in that backup exposure analysis and a strategy analyzing and doing the math problem to understand whether or not the actual content of a chemical really does exceed that threshold level in the statute given the average consumption of the product.
Okay, that was a lot. Thank you.
Yeah.
I see another question here. First, Donna says, thank you for the presentation. She asks, how effective is a shelf label as opposed to the product label? Is a shelf label sufficient for compliance?
Yep, a shelf label is absolutely sufficient. The statute gives you 5 different types of labels, some online. And so if you sell something online, you absolutely have to have that online label. You can put the sticker on the product. You can put it on the shelf as well. You can put it on the packaging. Obviously, you wouldn't put it on a tortilla chip. You'd put it on the bag. In terms of if you were to rate the types of labeling, I think that if you do a lot of sales volume in a type of product that is interesting to plaintiffs' attorneys, the on-product label is probably the best, right? Because once the food becomes separated from its shelf tag label, you don't lose that warning mechanism. But the shelf tag labeling from a marketing perspective, I think, is a lot more appealing to food folks in particular than the food product actually having that nasty little sticker on it wherever it goes. So that's a question of risk and what you prefer.
Okay, thank you. I see one more, or maybe two. If a company puts a warning on their product, is that an admission of product liability?
From the Prop 65 standpoint, it's not an admission. It's what the statute wants you to do. If you were to take into context all the other product liability laws that are out there, I mean, I have never seen any claims like that. I think it's a great question. And it kind of comes back to this issue of the specter of the label and what the label evokes in people's minds. And its language is incredibly unpleasant. So I like to advise my clients that if there's any way that you have a little bit of money to invest in this compliance workup, understanding, working with your suppliers, understanding if there really are measurable amounts of the chemical in it in your products, and you have a way to push back, it's nice to be able to push back. But in direct answer to your questions, I haven't seen any claims like that. So for the most part, that's good.
Yeah, I hope that's true. Okay.
Yeah.
Then, Sophia, I have our last question, unless we have any more put in the chat room. Is there a scientific firm that you recommend for conducting this testing that you could share with us so that we could share with them?
Oh boy, they're going to be so excited. So there's one firm that I always work with, and it's Exponent, and you've probably heard of Exponent. They do a lot of toxicology work, from Prop 65 to, I don't know, asbestos claims to polluted sites and polluted water and all sorts of things, which is the world in which I live. There are a lot of other consultants out there too, and I think that range in cost. So if you'd like a list or you'd like to know some more folks that I work with, I would be more than happy to share it. And there's one individual in particular at Exponent that I do a lot of work with in the food world, and she is back east near a lot of you. So she's in DC.
All right, that's good to hear. And I know you and I will work together on that in the future. So I can maybe get more recommendations on that. I think that's all we have for the questions. Your presentation was terrific. Thank you again, Sophia. I want to let everybody know that the presentations will all be available through AFI in the coming week or so, late next week perhaps, with a survey, and the slides. You'll be able to review them again, on your own time. I want to thank Sophia and all the speakers for joining us today. I'd like to thank the sponsors for making today a possibility for our AFI members. And I'd like to thank all of you too for participating today. Day one seems to have gone very smoothly, and I think that it was very productive and worthwhile content-wise. So watch your email for later today at 4 o'clock, and again tomorrow morning you'll see tomorrow's Zoom login information for day two. We'll once again begin tomorrow morning at 10:45 for an informal meet and greet, and the sessions will begin as scheduled at 11 a.m. We have another terrific slate of speakers, as you can see, for tomorrow, and I look forward to seeing all of you again then. Thanks again, enjoy your evening, and we'll see you in the morning.
So long, everyone.
Bye-bye. Thanks.
Bye-bye.
Everybody.
Bye, thank you.